Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division, draw near. The defendants, and it shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division, First Department. We have over 6 hours of argument time requested. So I'm going to ask that you request only what you actually need, not what you want. Understand that the time clock is for you, not for us. So if the members of the bench have additional questions, I'm going to let it roll. So please don't be offended if I cut your time short. Understand that if my colleagues have additional questions, I will provide the extra time for that. Okay? People versus Luis Tejada.
Good afternoon, Your Honor. Upon request.
5 and 1 and 5. Again, ask for what you need, not what you want. TWU Counseling versus New York City Tax.
Jonathan Cohen, Your Honor, on behalf of TWU Counseling Center, I respectfully ask for 7 and 3.
6 and 2 and 6. W. Muhammad is submitted. Muroff versus Hearded.
Your Honor, for the appellants, we'd be requesting 7 and 3, please.
Respondent? 5 and 1 and 4. People versus Jelani L. Submitted. International Business versus Global Foundries.
Robert Atkins, at the appellate IBM, like 7 and 3.
Your Honor, I'm David Leonard from Long Island, Global Foundries.
6 and 2 and 6. Ramroop versus Stein. Submitted. Ozimek versus DeJoseph.
Respondent, asking law firm 3 minutes, please, Your Honor.
Respondent Joseph, 3 minutes as well.
4 and 1, 3 and 3. People versus George Silva. Submitted. EMFT LLC versus New York City Department of Transportation.
Michael Fonsos for respondent cross appellant request 3 minutes and 1 minute as well.
Okay. 6 and 2, 3, 3, and 3 and 1. Singer Equipment versus Chapin School.
Good afternoon, Your Honor. Wilbur Trevino here for the defendant appellant, requesting 7 and 2.
John, what would you ask for? Responding Chapin School, requesting 7.
5 and 1 and 5. Hahn versus Prince Development. Submitted. Sen Park Realty versus Gurin.
For the defendant appellant, Solomon Dabrowski, Adina Marmalcy. Adina Marmalcy.
How much time, sir?
5 and 3.
Respondent requests 5 minutes.
5 and 1 and 5. 5's 1/60th and Zhao.
Your Honor, appellant request 7 and 3.
Respondent requests 5.
5 and 1 and 5. New Deal versus 684 Ownership Corp. is submitted. First case on the calendar, People versus Luis Tejada. Counsel, please come up. You may proceed.
May it please the Court, Tabitha Cohen from Cleary Gottlieb, Steen and Hamilton, of counsel to the Office of the Appellate Defender on behalf of Luis Tejada. The parties agree that defense counsel repeatedly misstated a crucial aspect of the law in this case before, during, and after the trial, both in front of and outside the presence of the jury. The only dispute, then, is whether this fundamental error requires reversal. It does. Counsel's misunderstanding of accomplice liability related to the key theory of the case, the charges against Mr. Tejada, the prosecution's
Let me
burden.
ask something. How was defendant prejudiced by this, assuming it was true? Because it's clear that the defense that was presented during the trial was that he was not participating in putting the heroin together. He was just happened to be present. How was any mistaken belief about this defense have anything to do with impeding that argument?
Yes, Your Honor. Had counsel properly advanced a bystander defense, that would have likely been the best defense in this case. However,
A bystander defense?
Yes, exactly what Your Honor was saying.
I know, but the facts here really don't support that, do they? The man was standing in a room with a table full of heroin and other drug-preparing paraphernalia. So there's no question that anybody standing in the room with eyes and senses would know what was going on.
Yes, Your Honor. However, there was a months-long investigation. It was several months long. It involved several agencies. They did multiple surveillance operations. They had never seen or heard of Mr. Tejada before they found him in the room that day. There's absolutely overwhelming evidence.
Is there any evidence about how much time he was in the room prior to the police officers coming in with the search warrant?
No, Your Honor. They have no idea he could have entered only minutes before.
Is there any evidence to support that?
Well,
He was sitting in a room deep inside the apartment that had a lot of heroin, a lot of drugs, and a lot of drug paraphernalia in it.
Yes, Your
So
Honor.
an innocent person walking to a room like that turns around immediately and walks out. So what evidence is there to support that that was the situation your client was in?
Well, it's impossible to prove a negative. However, it's the prosecution's burden to demonstrate when he was in that room, for how long he was in that room, and that he was actually involved in the operation. However, here they did not demonstrate.
Even if you're saying that's the argument, he did make that argument. That was the argument that defense counsel made at the trial, the bystander argument, that he just happened to be present and was not involved in the heroin packaging. So how did this misunderstanding of the defense affect his ability to make that argument, which was being made?
Yes, while he sometimes suggested that Mr. Tejada was just a bystander, he polluted that defense by effectively conceding his guilt under an accomplice theory of liability. He opened his summation by saying that Mr. Tejada cannot be found guilty unless he was charged with conspiracy or acting in concert. And throughout his summation, he said that Mr. Tejada could have been...
You just said something that's important. You said that he conceded his involvement. How? When he's saying, at worst what he said was the undeniable, which is he's in the room, right? But he didn't know what was going on. He wasn't a part of it. How exactly did he concede anything?
No, Your Honor. He actually said, counsel argued throughout the summation that Mr. Tejada might have been involved in the operation, but just wasn't working there on March 6th. He said that he was there picking up money on March 6th.
When you say that there was no other indication that he was involved, there were text messages involved, correct?
The text messages were quite vague. In most of the text messages...
Nonetheless, there were text messages that the prosecution alleged came from the defendant to other members of whatever was happening, correct?
And most of those conversations were words like thing and that. They were very vague terms. So, in addition to him being in the room that day, where the only other evidence is this vague cell phone messages, they were fewer than 10 messages, with half of those being thing and that.
Also, more importantly, how is this reviewable? You didn't take a 440, did you?
No, however, it is reviewable on direct appeal because, as the prosecution noted, it is evident from the face of the record that counsel misunderstood the law, that he was not capable of providing Mr. Tejada with meaningful representation because he misunderstood a key aspect of New York criminal law and a key aspect of this case.
What would have been the difference if he did, as you say, understand the law properly? What other defense could have been asserted other than, yes, I was there, which could, as my colleague has aptly pointed out, could not be denied? So the defense seemed to be kind of fixed into the fact pattern, no? I mean, he had to acknowledge he was there because he was there. And so there were very few defenses available to him, am I right?
Correct, Your Honor. However, even assuming that counsel had advanced a pure and reasonable bystander defense, he then also made these very damaging companion theories that there's no accomplice liability, that he can't be found guilty under an acting in concert theory, and essentially ruined his credibility with the jury by making these arguments that were then directly contradicted by the jury instructions that said that the jury can find him guilty under an acting in concert or accomplice theory of liability. So he tainted his credibility with the jury and polluted any bystander defense that may have been.
Okay, I believe my colleague has a question.
Could you address the excessive sentence claim in view of the seriousness of the charge?
Yes, Your Honor. This was Mr. Tejada's first ever involvement with the criminal justice system, his first arrest, his first conviction, and he should have gotten the minimum. He'll be released when he's over 50 years old regardless and have a significantly lessened risk of recidivism. And it would be a modest reduction to only 1 year to give him the minimum sentence. And this court should reduce his sentence to the minimum in the interest of justice.
And wasn't the court justified in adding that additional year because of your client absconding?
I'm sorry, Your Honor?
Because of your client not appearing?
As we argue in the briefs, Mr. Tejada was only warned once of his Parker warnings before the trial even started, and his confirmation of his understandings of the Parker warnings was not made on the record. So,
are you suggesting his counsel did not properly advise him? Every defense attorney close to trial tells their client, you got to come back, because if you don't, that's an additional charge, and they can go forward without you. He received that warning. Why should he not be held to that?
Because the consequences of failing to reappear were not made on the record, it's impossible to know what admonishments Mr. Tejada would have been given off the record. However, regardless, we believe that an extra year of his life was not warranted here, and a modest sentence reduction would be justified, seeing as this is his first ever arrest when he's a middle-aged man.
Thank you.
Thank you, Your Honors.
Counsel, I'll hear you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. This court should affirm because the defendant's conviction, primarily because the evidence...
Let me just ask you, getting to that last point, it's clear here that the lower court enhanced the defendant's sentence by a year due to the defendant absconding. Is that a proper basis on which to enhance sentence?
It is, Your Honor.
Well, wouldn't the proper method would have been for your office to bail jump him, charge him, and then convict him?
I can't speak to why our office didn't pursue those charges, Your Honor, but I think...
Isn't this tantamount to the judge punishing him for something that he hasn't been convicted for?
Your Honor, I think the court recognized that not only was a defendant... I don't think it was based on the basis of a potential bail jumping guilt. I think as
it had to be. Well, because the other defendants who had longer sentences and copped a plea got a better deal. So the only reason for hitting him harder, since he's a first-time arrest and based on the fact pattern in your own case presentation, he's a low-level guy. So really, the additional year was a punishment for his not returning to court. And is, as my colleague has pointed out, is that not an inappropriate basis to enhance punishment?
And if I may add to that, the quote here that I have is, "But I am also considering the fact that you absconded during the course of the trial and that you failed to return, and I am enhancing your sentence accordingly.
So I think I can speak to a couple of points in there. First, as to the sentences that the other defendants received in this case, those were pursuant to a plea agreement to a lesser charge.
I understand, but they were also more culpable. So we're not going to play pretend, okay? You gave smaller sentences to people who were more culpable. And the only reason this guy got hit as hard as he did was because he foolishly did not return to court.
Well, he also proceeded to trial on the top charge.
And so we're going to punish him for exercising his constitutional right
Certainly
to
not,
go to
Your Honor.
trial?
Certainly not.
You
But the law-
mention it, so it obviously was a reason for enhancing the sentence, which would be inappropriate.
Your Honor, the minimum on the top count in the indictment was 8 years in prison. That is the minimum he could have received. The other defendants who pleaded guilty in this case pleaded to lesser accounts that carried a minimum sentence of 3 years. And defendant also received this offer. So that was on the table from the beginning of the case. All the defendants received.
I get it. You see, the problem is that people who are less experienced in the criminal justice system, who are not hard, entrenched criminals, don't understand the plea bargaining process. And so people who are entrenched will avail themselves of plea bargaining, as these defendants who pled before him did. But they were the more culpable, yet this guy does more time.
Well, I would dispute your characterization that this defendant is not as culpable as any of the other people in that room. They were all in the room together working towards the same objective.
How many times was this gentleman in any of your recordings other than some of the more principled defendants here?
Well, there are numerous text messages that are in evidence that show that he was deeply and intimately involved with all of these defendants prior to March 6th.
And how many do the other guys have? 30 and 40 text messages? Yet he does more time than everybody else.
I mean, the evidence that was put before the jury, it's pretty even among, I mean, all of the defendants' phones were recovered from the room. The text messages that are, I can't speak to the text messages that weren't admitted into evidence because there were other defendants who were not on trial, but there are numerous text messages between this defendant and multiple others prior to March 6th. So,
But you can't compare that to the number of text messages that were involved with the people with the defendants who pled, because you don't have those, right?
that's correct. So I can't speak to that, but as far as defendant's culpability is concerned, I don't think there's any dispute that he was perfectly aware of what was going on and that he was there for the sole purpose of packaging heroin. As to the point about the sentence, Your Honor, again, the minimum this court could give is 8 years. So comparing the sentence that the other defendants received as part of a plea deal to a lesser sentence is not appropriate, because once defendant proceeded to trial, the least he could ever receive was 8 years. As far as the aggravation of his sentence regarding absconding, I think the court recognized not only that defendant was perhaps committing a crime, but also that he was doing so on the eve of the verdict after a weeks-long trial in which both sides put forward a case. 16 jurors were present. And the court noted that in its reasoning as well, that essentially, well, defendant, you have wasted the time of this court and the jury, and that was largely the basis for aggravating a sentence. And we would submit that that's perfectly appropriate.
Wasting the time of this jury. Did you hear what you just said?
That
is a constitutional right in this country.
But
I have a right as a U.S. citizen to insist that the people prove their case. That should not be a measure to augment sentence.
Just to be clear, Your Honor, the court was not penalizing defendant for proceeding to trial. He was penalizing defendant for absconding on the eve of the verdict and causing the warrant officers to go out and find him days after the jury was ready to render a verdict. And the jury had to wait around, and there was a Parker hearing that was held, and that was the basis of the court's determination. The court was not penalizing defendant for proceeding to trial.
Thank you.
Thank you, Your Honor.
Counsel, you have 1 minute.
Thank you, Your Honor. Very quickly, as Your Honor has noted, this is a classic example of the trial penalty where Mr. Tejada's minimum is 8 years when the leader of the operation, Albert Rosario, who's the one who was being investigated for several months, he was the boss, he was the one profiting off of this. He got 3 years and has already been released by now, while Mr. Tejada languishes in prison with an 8-year minimum, and he received above that minimum when at most he was a menial worker in the mill that Rosario ran, and he was penalized for taking his case to trial. So this was an inappropriate basis on which to enhance his punishment.
Well, in fairness, he didn't help himself by not coming back. So I don't blame the court nor the prosecution for taking umbrage to that.
Absolutely, Your Honor. However, this was not worth an entire year of this man's life. And for all these reasons and those outlined in our brief, Mr. Tejada's sentence should be reversed and at minimum reduced to the minimum. Thank you.
Thank you so much, both of you. Matter of TWU.
She's with a firm. She's with a firm.
Oh, thank you so much, counsel, for your pro bono service in this matter. And thank you to my colleague for reminding me of that. We appreciate it very much.
Thank you, Dr.
Good afternoon, gentlemen.
Good afternoon, Your Honor.
Okay, first one up. You may proceed.
Yes, Your Honor. Jonathan Cohen for TW Counseling Center, appellant and petitioner. Your Honor, this case involves a situation where a Bronx Supreme Court judge reversed and vacated a prior order of...
Counsel, let me ask you a question. On this tax issue here case, are you precluded from going back and asking for reconsideration?
Yes, Your Honor.
Tax that you can't go back there anymore. You can't.
That time period has long passed.
No, for something new. I mean, if you were to change, I guess, in terms of getting tax exemption for this property, if you were to do something else different, could you go back and ask for tax exempt status?
Well, Your Honor, interestingly enough, this property has received a tax exemption for the past 4 years. And this, I mean, that's judicial notice for Your Honor to understand. But this is a situation where the tax exemption was rejected initially by the two agency defendants. The Department of Finance issued a blatantly undisputable, irrational, arbitrary, and capricious rejection. It's undisputed.
So let me ask you a question. Before the tax tribunal, you only had an attorney affirmation?
Before the tax commission, there was an extensive record, Your Honor.
I asked you a question about what was in terms of witnesses before the tax tribunals.
Your Honor, it was a combination of affidavits, sworn affidavits, that set forth the justification for the tax exemption. It was my sworn testimony.
Anybody else but yours?
No, Your Honor.
Just yours. So then in the Supreme Court, though, my understanding is that the business, or at least the entity that was going to help or assist the TWU, put in affidavits before the Supreme Court?
There was an affidavit put before the Supreme Court, Your Honor, and that clearly stated that NHS never...
Well, why wasn't that put before the tribunal, before the administrative agency?
Because at the time that it happened, we had no idea. First off, there was compelling evidence that we planned to do only education and counseling services. The court approved us to do that. The Attorney General approved us to do that. We retained NHS to do education and counseling. NHS had received tax exemptions on its own property for 10 straight years. They received exemptions for everything they did before, after, and during the year that we filed for our initial exemption. I had no idea, and the Department of Finance never rejected us based on what NHS did. I was blindsided. And in fact, the Tax Commission did its own independent, secret review of documents. And they gave us an unforeseen decision 16 months after our hearing. Never once did they ask a single question about documents that they relied on, which was tax returns and an agreement that we had with NHS. So we had unrebutted sworn testimony from me, unrebutted sworn affidavits, briefs, facts that told the tax commission that we would do an education and counseling, that the court and the Attorney General required us to do education and counseling. Department of Finance sat in
Did your
silence.
testimony, counsel, address any of the issues which were later submitted to the Supreme Court in an affidavit from someone from NHS? Did your testimony address those issues, like the fact that the tax returns showed a large amount of loans being made?
Did my testimony address that fact? No, my testimony simply said we are using NHS to do education and counseling. We're aware that they do. Yes.
How did your testimony counter the actual documents which showed in the tax returns that a lot of NHS's business was giving loans, that was a major aspect of their
Counsel,
business?
and I need you to put your mask on.
Oh, yes, I'm sorry. Yes.
I know it's uncomfortable. I don't like it any more than you.
Thank you,
okay?
Your Honor.
All right.
My glasses fog up, too.
Mine too.
Yes,
You see, I
but
took mine off.
real quick, Your Honor, the issue of the documents in NHS, 2 quick points. One, the tax returns point out they're an abstract document. The NHS affidavit.
What do you mean they're an abstract document?
Well, what I'm saying, when you mention lending in a tax document, NHS's primary lending activity is actually giving fully forgivable loans that are essentially grants. They give $30,000, $50,000, $15,000 grants.
So what documentary evidence was provided in the record to show that, so as to kind of counterbalance all of these loans that seem to be more like assets?
Well, before I knew that that was a reason to reject us, I had no reason to know that I needed to address that. And in fact, NHS has never done any lending activity at the property. Never.
But
So
how
that
can the tax commissioner decide the case on anything other than what is before the tax commissioner? And in the absence of any testimony from anyone at NHS at the hearing as to what NHS did or did not do in their business, how can you argue that their determination, which reviewed a document you submitted, the tax return, was arbitrary and
I
capricious?
was asked for the tax return. 2 reasons. We weren't using NHS. NHS doesn't own the property. We're not using NHS to do lending. We're using NHS to do education and counseling. It's undisputed that that is a substantial part of their business. In their own affidavit, when we realized it was an issue, they pointed out that they've never done lending at this property. That
didn't happen at the hearing, though. That happened at the Supreme Court that all got brought out.
But what I'm saying, it was pure speculation for the tax commission to say, we believe you retained NHS to do lending because it's in their tax returns. But that's not why we retained NHS.
So what documentation did you provide to show what exactly NHS was going to be doing on your property?
I unrebutted sworn testimony, unrebutted sworn affidavits. From who? From the client. And
At what
from
point? Was
myself
that before the
as
administrative
an officer of
agents?
the court. I'm an officer of the court.
Was that before the...
Counsel,
Yes.
please allow my judges to ask you
Oh, I'm
questions.
sorry. I'm sorry, Your Honor.
When you say sworn testimony, unrebutted testimony, at what point? Was that before Supreme Court or before the administrative tribunal?
The Supreme Court, the tribunals was before the Supreme Court.
It's a very, yes, so that this
Supreme Court
unrebutted...
wouldn't allow me to testify.
Okay, I got it.
I'm sorry, Your Honor.
Counsel, understand that we must assess this appeal based on the record before the tribunal.
Right.
So if you added additional information during the motion practice in Supreme Court, that was not before the tribunal.
Understood.
And so we will not consider it.
Understood.
Okay.
What I wanted to say is that the testimony and the affidavits combined with court orders which said that we must do education and counseling as our primary activity.
Yes, but counsel, the fact that an order says you must do educational programming doesn't mean that that happened.
Right.
So that is not proof that that happened.
Right.
I'm going to give you a chance to respond after I hear from your adversary.
Okay, thank you.
Counsel?
Good afternoon, Your Honors. Eden Burkett, City of New York. There's a lot that...
Counsel, I would like to ask you some questions about the excusable default.
Okay.
The only evidence I saw on the record to establish your excusable default was the affidavit of Ms. Cox, right?
Correct.
Okay. And she didn't claim any actual personal knowledge of what happened to the Article 78 papers, correct? She speculated. She didn't actually have any knowledge.
Your Honor, she supervises the paralegals.
I know what she does. Does she have any actual personal knowledge of what happened to the Article 78 papers in this case?
The error in question happened prior to her becoming aware of it. She became aware of it subsequently.
Right, so she doesn't have any personal knowledge.
She has personal knowledge of the procedures for how the mail is handled.
I didn't see where she set out anything about what the procedures are. I mean, I have her affidavit here, and it's very short. It doesn't set out any procedures for reviewing the mail.
Your Honor, the procedures in the affidavit, as well as in the accompanying affirmation of Anthony Forzaglia, Assistant Corporation Counsel, indicate that the procedure, the City of New York is a party to nearly every...
I'm sorry, there's no, I'm looking at her affidavit. I don't see any procedures, except that the documents would have gone to her division, but there's nothing that sets out what procedures then followed.
Your Honor, with respect to the question, the lower court carefully reviewed this evidence.
I know what the lower court did.
Counsel, I'm going to ask you, trust me when I tell you, just answer the question straight, okay? Proceed. You're better off.
Where does she set out a procedure for deciding what documents go in what pile? I don't see any procedure in her affidavit.
I don't have the affidavit in front of me, Your Honor. I can't, the court can review it.
All right, so let me ask you another question. Even assuming that the city had a good reason for not responding when they got the Article 78, I don't see any explanation in Ms. Cox's affidavit or anywhere else as to why the city didn't respond when they were sent the supplemental affidavit by petitioner's attorney, and why they didn't respond when they got the copy of the order with notice of entry a month later, and didn't do anything to vacate their default until almost a year after, in 8 or 10 months after the initial proceeding. Why was there such a long delay?
Again, the reason was that the proceeding was erroneously closed and deleted.
But there's nothing in the affidavit showing what happened to the supplemental affidavit, right?
The affidavit speaks for itself, but I think that the reality is that the sum and substance of the affidavit is that the original proceeding was erroneously marked as a foreclosure
I understand
matter.
that, but I'm talking about the follow-up papers.
The follow-up
You have no
papers-
documentation or no affidavits as to what happened with those, right?
It's the same. It's all one continuum. It's it was the initial.
Is the
error.
same procedure followed when additional papers come in so that any judgment or a notice of entry of judgment by plaintiff's counsel that might have been sent, would that have gone through the same procedure as did the original filing?
Yes.
And so do we have any documentation as to what that process was and what the timeline was? Because it is, you know, look, we understand that the city has thousands upon thousands of filings. But that does not equal that the city gets a free pass on following the law. So you have to at least show that there has been some semblance of an attempt to follow the law. That is what my colleague is asking you about. Can you please address that?
Your Honor, the default was unintentional. It was not any sort of, the process certainly, there are certain problems with the process, but...
Counsel, would you agree with me that Ms. Cox's affidavit does not address anything except the Article 78 petition itself?
Your Honor, I don't have the affidavit in front of me.
Okay.
If I could briefly address the other, well, and I guess just as a follow-up, again, the lower court took this into account, and in fact took some issue with the question of the law office failure. However, there is a balancing test. It's not simply one factor, and the fact that this was the court, in a careful use of its discretion.
Can you address, I want to just go
Okay.
past this issue for a moment and ask you, your adversary stated in his presentation that NHS has been basically approved for this type of work under this status in the past for many years. So why should we block it here?
Unfortunately, I can't detail in the amount of time that I have. My time is.
Counsel, like I said, I am the chief of the clock, so don't worry about the clock.
I could go on for a long time. Unfortunately.
Why don't you start and answer
Petitioner-
that question?
The sum and substance is that petitioner's counsel is the argument and many of the statements regarding the entitlement to the exemption and the entitlement to the existence of exemptions and other properties require, some of these facts are not within the record. Others require a suspension of disbelief and a blindness to the record. The fact is, at the hearing, if you look at the transcript of the hearing, petitioner's counsel made this argument that NHS had received other exemptions, and it came out at the hearing that, in fact, some of those exemptions had been revoked. So the record is not so clear on this question of NHS being automatically entitled to an exemption. And in fact, while petitioner's counsel has made a great length to say that this is education and training, what this is these are prerequisites to loans. These are home buying courses. They're not free, by the way, and they are essentially, most of these are required for the loans. And again, these are money loans secured by mortgages. The idea that these are grants requires a really strained reading of the record. In fact, these are loans, some of which involve partial forgiveness if the contingencies are made. So again, the record is clear.
Does that not qualify?
The
So my question is, if mortgage loans are made with contingencies that the borrower maintain and continue to pay off the mortgage for a period of 5 years and stay in the property for 5 years before they're eligible to receive the grant and forgiveness of part or all of the loan, have those not been sanctioned by our court in the past?
In fact, there are two principal cases. There's a case that this court handled in 1949, the Providence Loan Society.
But Provident Loan wasn't a not-for-profit, unlike either of the entities at issue here.
And we have about 1 million new loan programs since 1949. So if you can come up a couple of decades, that would be helpful.
The principle still stands. The 2004 case from Rockland County Supreme reviewed this and concluded that the Provident Loan Society, which was affirmed, the lower court said that the admirable intentions of the lender and the tangible benefits to the borrower, and the fact that the loaning of the money wasn't the point, it was the benefit to the parties, wasn't, that the lower court found that this was charitable. This court reversed, and the Court of Appeals affirmed, and the Rockland County Supreme Court interpreted this as essentially standing for the proposition that lending money at interest with collateral has never been considered charitable. And again, it just...
In the Rockland County case, the exemption was granted, right?
Yes, because that was a religious free loan society where there was no interest and there was no collateral. So these are bookends. These are two principles that stand for, one is charitable, which is essentially lending out money with no interest, no collateral. That's charitable. This is not charitable. This is essentially NHS partners with banks, and these properties, if you look, if I could cite one part of the record, I won't read it, but the agreement between NHS and TWU at 180, starting at 180 of the record, if you look at the agreement of what NHS would be providing, the word grant appears nowhere. The word forgiveness appears nowhere. The word loan or loans appears 19 times. And there's mortgages appears several times. The only where it says free is where NHS would receive free rent.
Thank you.
Thank you.
Okay, counsel.
Yes, Your Honors. On the issue of excusable neglect, which is required to vacate the 2019 order, it is clear that in this case, the sole piece of evidence is 2 sentences from the Caroline Cox affidavit. It is hearsay of a law clerk speculating what a paralegal did. There is no detail. There is no specificity. It is general. It is conclusory. It completely, as you correctly noted, ignored numerous additional events of default and neglect. The May service doesn't even get mentioned. When you look at the case law that I provided to this court, repeatedly the appellate division has held over and over that in order to qualify for finding an excusable neglect and to vacate a default judgment, you must have an affidavit based on firsthand knowledge. That's the only way to be credible. We don't
So wait a minute. The affidavit said that our procedure is if a law clerk, if a paralegal looks at a mailing and believes that it falls under mortgage foreclosure, there is a particular procedure they follow and ultimately ends up in a close without anybody else checking those documents. Am I right?
That's what they said.
Okay. And do you have, did you submit anything that contradicts that fact?
Yes. First off, we provided a couple of things. We had an explicit petition of an Article 78.
Counsel, what I'm talking about is, do you have anything that contradicts that that is their procedure in their office?
No.
Okay.
No.
So then what we have next is a statement that says, according to our paperwork, because it tells us when it was received, that it was looked at and it was closed, correct?
There was no such detail. There was zero detail. This is a vague, general statement. That's all there is. It doesn't explain at all why they ignored a May service, blatantly ignored it. Why did, of a reminder to come to court? They don't even mention it. They don't mention that they got the court order on July 3rd.
Those are post what I'm talking about.
No, but what I'm saying is,
Those are post what I am talking about. So if you want to jump ahead, that's fine.
Your Honor.
But I'm talking about one thing, and you're jumping into something that happens much later. But okay, you continue.
Your Honor, I can't refute a vague speculative guess as to why they lost service on April 6th. It's impossible.
They didn't say they lost it.
They did. They actually
said
the
that
petition was marked as open, closed, and then discarded.
That's not lost.
Okay?
I don't read that as being lost. They said they discarded it according to their procedure. Now, you may take issue with that procedure, but it is a procedure.
Okay. Okay. That procedure, based on a hearsay statement, which is explained in the last brief as a probability of what may have happened, doesn't qualify, Your Honor, for what the appellate division requires.
So if a manager says, my staff is required to do X, Y, and Z, and if that person says, my staff, in an affidavit says, my staff is required to do X, Y, and Z, that's not enough?
Your Honor,
to explain what the proper procedure in a particular office is?
Your Honor, with all due respect, if you could simply say, of course they did something wrong. If you said our procedure wasn't followed to answer a complaint, and that alone allows you to get a finding of excusable neglect, there would be no requirements would matter, because here they simply said, of course they some procedure went wrong. But they had the opportunity, and the questions that you asked, Your Honor, I asked these over and over to the court below. There's simply no answer for why they ignored May, why they ignored June, why they ignored reminder. And what the record shows is repeated neglect and default over and over, and then an affidavit that is black letter example of an inexcusable neglect, because there's no explanation that provides firsthand knowledge, that provides detail, that provides specificity. All we have is vagueness, we have mystery, we have generality, and we have a blatant sort of ignoring of the fact that they keep ignoring. Why didn't they answer the complaint in May? There's simply no explanation, because even if they lost or miscarded or mismarked the pleading in April, when they were served again in May, they don't even attempt to explain why, when they got an affirmation to enter judgment in Article 78, did it just get ignored? There's no explanation for that. And the judge, we had 2 scheduled hearings, and when I appeared in front of Judge Mills had a thick petition. She read it carefully, and she said, where's the city? She looked at the service records, and she said, you've presented a valid reason to get your tax exemption, and the city ignored it. And then they ignored it again in September. They were told 4 times in written letters, undisputed, you have not honored this judgment. I wrote to the city personally over and over and over, and then they even waited another 5 months. There's a case right on point that is virtually exactly the same facts as this case, where the appellate division said, maybe you had a valid excuse for losing the file in the first instance, but there's no excuse for why you continue to ignore additional reminders and service. And in this case, by the way, they only came into court when I entered a 2008 money judgment. So this is a blatant sort of contempt for the court rules, and it violates every single requirement that the appellate division has said is necessary to get a finding of excusable neglect. So the fact that the city says, well, of course we wouldn't do it intentionally, that's not the standard. You don't have to prove what was in the mind of the city. But the city has come to this, went to the court below and said, here's a vague, speculative, hearsay affidavit. It breaks every single rule that is in existence. And then they continue to ignore reminders over and over and over. And they waited, like you said, almost a year to bring this application. So regardless of the merits, this original order should have never been vacated. It's simply reversible error.
We should not at all consider the merits.
The merits, I mean...
So whether a company is entitled to tax exemption on the backs of New York State residents is of no moment.
No, I'm not saying that. I'm saying that...
But at the end of the day, this decision will make that a reality, right?
But Your Honor...
So that if this company is not entitled to a tax-exempt status on the merits, we should nonetheless grant it because of the lax response by the city. Please take that back.
In this
Is that what you're arguing?
Your Honor, 2 things. One, that is the law. That is the law. It doesn't matter what the merits were. But in this case, the merits were overwhelmingly in TW's favor. The merits were laid out.
I don't know about that,
Okay,
but
but put it this way, there certainly was...
Counsel, I have your arguments. We are about 5 minutes over time.
Great.
Thank you.
Thank you very much, Your Honor. Thank you.
Judge Kern is recused from the next case, Muroff versus, who's the first defendant? Heritage and Memorial Hospital. You may proceed, counsel.
Thank you, Your Honor. Thank you. Good afternoon. May it please the court. My name is Jacqueline Mandel. I represent all of the defendants' appellants in this case. This appeal today is about proximate cause. There are 2 separate claims for 2 separate periods of time, and with the court's permission, I'd like to address them each individually to demonstrate why the plaintiff's proof was insufficient to raise a triable issue of fact on proximate cause for both segments of the claim. First, we're dealing with chronologically the alleged 6-month delay in performing the surgery. So this happens between April 30, 2015 and the day of the surgery, which is October 19, 2015. Yes, because I imagine that you're going to ask me this, the parties' experts disagree on the stage of the cancer. There's no question about that. However, it's a distinction without a difference in this particular case because it all leads to the same conclusion. Even just for a moment, putting my own experts' opinions aside on the staging of the cancer, it's the plaintiff's own proof that negates the possibility of proximate cause when it comes to this first segment of the treatment that's at issue, because the plaintiff's own experts told us that despite the passage of the 6 months, on the day of the surgery, the cancer was stage 1A, and the patient had a greater than 93% chance of survival on the date of the surgery. And what that means is that the cancer could not have, by the plaintiff's own proof, could not have progressed over those 6 months, and the life expectancy could not have been diminished over those 6 months. So at the very least, the claims that pertain to the treatment prior to the surgery need to be dismissed because in the absence of a causal connection between the departure and the harm, there cannot be actionable negligence as a matter of law. Moving on to the second part, which is the surgery itself. There's a claim that the defendant's surgeon didn't remove a mass and that there was then a delay for a few months in diagnosing her with cancer. And here, I'd like to refer this court actually to its decision issued just 2 months ago. It's called Foster versus Kassab. It's so new, it doesn't even have an official site yet. It's slip opinion 00007 from January of 2022. It is cited in my brief.
Counsel, I have a question.
Yes, Your Honor.
So when you said we're talking about the surgery that was performed on October 19, 2015?
Correct, Your Honor.
Right, and then 6 months later, I mean, that surgery, everything looked good, right? The way you're saying at that point, it was stage 1?
Well, I'm saying that you said 6 months later, Your Honor.
Well, before I even say 6 months, but that surgery, what happened was or the plaintiff's expert saying that it was stage 1, right? Is that what you were saying?
That's,
right?
yes, Your Honor, that's.
But did she not, did the plaintiff go back and complain to Dr. Slarkin on November 9, 2015 that she still felt a nodule in her left breast?
She did.
So what's the response to that? Because then he instructed the person, the decedent, to go back for 3 months later. So
that's right.
I mean, yeah, it's stage 1, but you know, a lot can happen in that 3-month period, no?
So that's exactly the point, Your Honor. We're not arguing whether or not there was a question of fact on departure. This whole thing is about proximate cause. What's the consequence of the departures that they allege? And in this Foster case, which if I put my glasses on, I can actually quote the important parts. Okay, this court held, and that was also, Foster, by the way, is a failure to diagnose gastric cancer. So this is breast cancer, this is gastric cancer, but the point is that this court found that the plaintiff's proof was insufficient on proximate cause as a matter of law, holding that a delayed diagnosis, even if it is a deviation, is insufficient standing alone to establish proximate cause. And what was wrong in the Foster case? The quote is, the oncologist offered no assessment of the stage of the cancer at the first consultation, its stage when it was discovered, and if there were a difference in those 2 stages, the resultant diminution in life expectancy or other injury. That's exactly this case, Your Honor.
Who was the panel on that case?
None of you. None of you. Justice Gish was presiding, and Justices Singh, Mendez, Shulman, and Pitt were the judges on that case.
Counsel, I understand your position that the plaintiffs, that they took the position that it was stage 1 cancer at the time of the operation, but you don't agree with that position, correct?
My experts say that she was stage 4 from the minute that she walked in the door. But no matter which way you analyze it, If
Oh,
my,
there's a big difference
there's-
between stage 1 and stage 4.
There's a
There's
huge-
like a million miles of difference.
there is. I completely agree with you, Your
And
Honor.
so somebody who's in stage 4, you find another tumor anywhere of any kind, that is like a huge red flag.
Your Honor,
A huge red flag.
Stage-
That means immediate action.
stage 4 is the final stage of cancer. It's terminal.
I know.
Okay. So either way, if you believe my experts that when she walked into the hospital in April and she was terminal stage 4, my experts said the prognosis isn't different, the treatment options aren't different, the
Except
survival
that
isn't
even
different.
people who have stage 4 have a chance at prolonged life. And nobody should shortchange that, right? So that if I have stage 4 whatever, I should be able to live as many more months as possible without that being impeded by improper medical advice, right?
Absolutely.
Okay.
And that would be a critical point in this case if that was the plaintiff's claim, but it's not. They're not claiming that. I cited it for you in my brief. Plaintiff's counsel during the argument said that she was curable. This cancer should have been cured. There's no question stage 4 cancer is not curable. This is not a Polanco case for that reason. If I can go back to the part about what happened after the surgery, Your Honor, I see my red light is on. I'll
Go
be
right
very-
ahead. I'm not stopping you.
Thank you, Your Honor. So going back to the quote that I said about the oncologist failing to offer any assessment of the stage of the cancer or its stage when it was discovered. So we have the surgery that's performed on October 19, 2015, which the plaintiff's expert says is stage 1. And then in February, only 4 months later, she has a positive biopsy. What's the stage? The plaintiff's experts don't tell us, exactly as in Foster. They don't tell us what happens in that interval. Did she go from stage 1A to 2? And if she did, what's the consequence? We don't know. Did she go from stage 1A to stage 3? And if she did, what's the consequence? We don't know. And that's what makes it conclusory, and that's what makes this case the exact same as the Foster case. It's conclusory. And then in February of 2016, when she has that positive biopsy, she terminates her treatment with us and has no more treatment until 5 months down the road, when she is beyond our control. We have no say in whether or not she's having surgery or chemotherapy or tamoxifen or anything that goes on. And the plaintiff's experts won't tell us what was the progression of the cancer. And that is why Foster is on all fours with what this case is about. And that's the reason that the second part of the case should have been dismissed. At the very least, the first part, where the plaintiff's own experts tell us that she was stage 1A on the day of the surgery, there can't possibly be proximate cause. And for the second half,
Are we not to consider that your people say that's not accurate?
we can consider it. The experts disagree.
So if I'm to consider that your people say it's stage 4, can I not analyze what was done for her based on your assessment? Because it was your doctors who were treating her. So should I not analyze this based on what they believed they were dealing with?
Well,
I mean, it seems to me that I should be considering the treatment of your doctors based on their assessment that they are dealing with somebody who is dying.
there's,
Right?
Your Honor, I'm not disagreeing with the point that you're making. What I'm saying to you is that in the normal circumstance where experts disagree, it matters, but here there's no difference, because at the end of it all, my experts say it wouldn't have made a difference because she was so advanced, and their experts say she was so early that it didn't make a difference. So even though they are at diametrically...
But you're not saying in that argument that if I ignore their assessment that it was stage 1 and agree with your doctors that it was stage 4, and then analyze what they did on the basis of what they believed, because they were the ones treating her. So quite frankly, For that purpose, I don't care what his doctor says. I care what your doctor says, because it is what your doctor thinks that dictates what they should do for this patient, no?
Well, we had the burden of proof on summary judgment for sure. And
I'm talking doctor to patient. All as a doctor and patient relationship, all that I need to concern myself with in evaluating whether your doctors did the right thing by this patient is what they believed, not what some other doctor says later in a lawsuit. I'm concerned with what your doctors believed and the treatment they gave this patient based on their expertise and their knowledge. Is that not what I am supposed to be considering?
well, I would love for you to consider my experts as the ones who are right.
Okay.
And my experts said, both of them said that my clients did the right thing.
Okay.
That's what they said. And their
But they're
experts,
saying that based on she was going to die anyway?
well, no, they said that Dr. Sclaren, the oncologist, got the patient to the breast surgeon in a timely manner, which the plaintiff's experts don't disagree with, right? They had a window and she met the window. And my experts said that the surgeons did the right thing in the surgery. They got all of that residual breast tissue out. That's proven in pathology. They had, before the surgery, 3 weeks before the surgery, there was an entirely negative breast MRI, nothing suspicious in there. The pathology comes back negative, nothing suspicious in there. And so my experts say, you can only remove what you can see and you can feel. There's a dispute about whether my doctors, there's competing experts on the departure, which is why when I opened, I said, this appeal is about proximate cause. It doesn't change. If she's stage 4, and they disagree with that, but if she's stage 4, she's terminal, and it doesn't change anything. If she's stage 1A, then the delay in getting her to that surgery didn't change anything.
Okay. I would suggest to your doctors and medical malpractice in particular, with the advances we have in medicine, stage 4 does not mean you die tomorrow.
There's no question.
So that the medical advice we receive can either keep us with our family for a year, 2, 3 years more. That is priceless.
Your Honor, she did.
So this concept of, oh, you're stage 4, so it doesn't matter.
No.
That kind of talk must leave our jurisprudence.
Your Honor, I think that's respectfully an unfair characterization of what went on
I'm
here.
just saying, I'm not saying that that's what you're saying. I'm clarifying for the record that stage 4 doesn't mean a death sentence tomorrow.
It doesn't.
And life can be prolonged. And every effort that can be utilized to prolong life should be expended.
We completely agree, Your Honor. And
I know you do.
Well, no, I really do.
I know you
really do. I do med mal. This is what I do, and I agree. And in fairness, she did live another 3 years from the day that she walked into the hospital.
Right.
And she did get surgery.
Counsel, if I could just ask you another question. I know you're way over time, but
I am over time.
when did the defendant doctors conclude that she was stage 4?
The defendant doctors?
The doctors. When did the doctors conclude that she was stage 4?
The defendant doctors did not conclude that she was stage 4.
Ever, right?
Never. Never. That develops based on what we see in the subsequent information that was happening after the patient left our hospital.
Okay.
They did not conclude that. If they had concluded definitively that she was stage 4, they might not have done the surgery.
Right, because she would
But
have qualified.
they gave her to Justice Manzanet-Daniels' point, they gave her that opportunity.
Yeah.
Right? She got the benefit of the doubt despite all of her radiology studies that showed that there were suspicious metastatic things going on in the liver and suspicious things going on in the spleen, and despite the 4 years before of all of this badly treated cancer, she got the benefit of the doubt, and she went to surgery, and she had reconstruction, and she had follow-up. And this went the way that it went anyway. And just to be 100% clear, Your Honor, there is no circumstance in which I am saying that a patient with stage 4 cancer is told, oh, well, so what, go home, you're going to
Oh,
die.
no, I certainly didn't intend to.
I don't want you to
imply that.
think that I'm thinking.
Not at all, okay? Not
you.
at all.
Thank you, Your Honor.
Okay. Counsel.
May it please the court, Guy Regev for the respondent. If I
Counsel,
may-
can you just address your opponent's argument that your own position that she had stage 1 cancer at the time of the surgery defeats your claim?
Sure. Plaintiff's or respondent's expert opined two primary things with regards to proximate cause in this case. The primary thing that was argued was that at some point between the types of scans that were done at Sloan Kettering and before to evaluate whether or not there was stage 4 and did not show there was any metastasis or stage 4 at that point. Between that point and the entire time she is being managed at Sloan Kettering, which again, plaintiff alleged was a delay, and that's not something that's being argued about today. Throughout the entire time that lasted almost 9 months, at some point throughout that time period, and this is stated explicitly in the affirmations, her initial stage 1 cancer progressed to stage 4.
So wait, because my colleague asked you a very direct question, and you haven't answered it. So why don't you try that again, Judge Rodriguez?
Opposing counsel's view is that your position that your client had stage 1 cancer at the time of the surgery defeats your claim. How do you respond to that?
So again, so number one, that is a mischaracterization of plaintiff's position, number one.
So you weren't asserting that at the first instance that your client was not suffering from anything over a stage 1 cancer.
Absolutely. You're correct about that. And in fact, what counsel is referring to is a statement made in plaintiff's respondent's expert affirmation, which states that according to all the information from all the tests, and I can go over each one of them, that was available at the time of the surgery of October 19th, 2015, according to all that information, all could be concluded is that at that point, according to that information, it was stage 1. However, in order to, and this goes into the topic of staging of cancer, in order to confirm exactly what stage a cancer is, there are 1 or 2 of the best methods, sort of like PCR testing and rapid testing with coronavirus.
Well, I would imagine that after the first cancer, that the tumor that was removed was biopsied, correct?
And when you say that is correct, the first biopsy, I think that is most relevant to the cancer we're discussing here, was in February of 2015. There was a biopsy. The biopsy, however, does not tell you what the staging is, meaning did it go to other places, because it takes a small sample from that area. In order to get the staging right, the best test that is done is called a PET scan. PET scan is, if I may, sugar type of solution is injected. Cancer cells tend to like sugar. Yes, I apologize.
We have many cases like this.
Yes.
So we know what a PET scan is.
Okay, so the PET scan is the best type of test. We know she had one on March 27th, 2015, that was interpreted by the defendants themselves not to represent any metastasis, meaning any advanced stage of cancer. Her cancer was determined to be localized. This is so crucial because regardless of whatever talk we have of the experts here, I know the expert opinions on the defendant's side, it's not perhaps my position to opine on your opinion here, but you were spot on with the way you interpreted it. How can you stand here arguing about what your experts say when the defendants themselves and all of their depositions and obviously all the notes, we have dozens of top experts from Sloan Kettering saying there's no advanced cancer here prior to that surgery. That's the reason they operated. If she did have stage 4 cancer, they all testified they would not even operate at that point. So the reliability of the of the defendant's experts here is below any sort of acceptable standard, in my opinion. Now, I will just point out, based on a question I heard earlier, if it's okay, that there are 2, even 3 main periods that we should think about here. And one of them is the time that plaintiff gets to Sloan Kettering and is being worked up for the cancer. And that time period, according to the defendants, should have taken 12 weeks from that time to surgery. They broke that, and she was evaluated for a whole 6 months. That's an initial 6-month period. And where our expert's position is that that period of time was a significant delay that led to a worsened outcome here. So that's number one. And then we have the period from the time that she has that surgery, which failed to remove the tumor, which is obviously an egregious act there, and extending to the time that they finally decided to listen to her complaints and test that tumor. And that's an additional 4 months. And from that time period, we know that now it takes another 12 weeks to try to get to a surgery again, because that's the type of cue, which would explain a significant time of that period that she had to get to another healthcare provider that she could trust after this horrible thing happened to her and before she left the 2 orphans, etc.
Thank you.
Yes.
Thank you.
Anything else?
Any questions? Thank you. Counsel, you have 2 minutes.
I might have misheard, but I actually thought that I heard Respondent's counsel say that they're not arguing about the 6-month delay before the surgery. I'm not sure if the court heard that. I thought that's what I heard. But just going to the expert opinions, page 1778 of the record is the plaintiff's expert, the 2 expert affirmations that the plaintiff submitted, with the exception of one is a surgeon and one is an oncologist. They're verbatim, so I'm only looking at the one of them. And plaintiff's counsel's attempt to reinterpret and translate what his expert said requires us to look at what the expert actually said. So if we go to page 1778, the expert explains to us what the staging system is for breast cancer and goes into detail about what it means and how they do it. And on page 1779, he goes 1 stage at a time and tells us very specifically, stage 1 is this, stage 2 is this, and gives us all of the criteria associated with all of that. And what that leads to is paragraph 129 on page 1780, which says, taken together, meaning everything that he just said in the last pages, Ms. Kujelski would be categorized as stage 1A on October 19, 2015, with a 5-year survival rate of more than 93%. There's nothing to be interpreted there. That's what he's saying, and I don't...
I don't have the affidavit in front of me. Does the affidavit go on to say at what point this expert believes she reaches stage 4?
It never happens, Your Honor. Paragraph 150...
Because it's a pretty fast advancing cancer.
If he's right...
If he's right that in 2015 it's stage 1, and less than a year and a half later...
Way less than that, Your Honor.
Right?
If he's right that in October of 2015, she's stage 1A, in March, she's got the positive scans where she's got lymph nodes. In July, she's having that surgery of 2016. We're talking about 4 or 5 months, but they don't tell us the answer to that question. If you look at page 157 of paragraph 157 of the expert's affidavit, which is at 1789 of the record, the experts, both experts tell us this, the other one's on 1820, is the other page in the record. To a reasonable degree of medical certainty, this patient's initially localized breast cancer progressed into stage 4 during the period between her initial April 30, 2015 presentation, which is the day she walks into our hospital, and the surgery that she has 14 months later on July 6, 2016.
But in between those 2 time periods, there are exams, right? Are there not?
And he tells us nothing. That's the whole point.
So aren't there scans done in between? A scan should have picked this up.
There was the surgery that was done. There were the pre-op scans, right, which I told you about that showed that they were suspicious for disease in the spleen. Nothing was definitive. Suspicious in the spleen, suspicious in the liver. There was the breast MRI done 3 weeks before the surgery in September of 2015, which was totally negative.
Then it's too late.
Then, but it was negative. Then there was the breast surgery, the completion mastectomies, not a microscopic scintilla of cancer in that residual breast tissue. The breast MRI is negative, and the pathology from the completion mastectomies are negative.
But is there an additional PET scan done?
No.
Because the fact that there's no additional growth in the breast does not mean that there's not additional cancerous growth metastasizing elsewhere.
Right, so what was going on at the time was, so she comes in April and they review her outside studies. She had had imaging studies in other institutions. Memorial does its own internal review.
Right.
There's nothing conclusive about metastatic disease. They refer her to the surgeon. She gets to the surgeon on June 11th, and she says, I want to consider reconstruction. So then 6 days later, she's in the hands of the plastic surgeon so they can talk about a complicated reconstruction given all her prior surgeries. She has to go through various tests and evaluations to figure out, does she have blood vessels? Does she have skin? What can we do with her? And that's all completed in July and August, trying to figure out what we're going to do with the breast surgery. In the middle of September of 2015, she says, okay, I'll have the surgery. The next week, she goes for that breast MRI, which is negative. And 3 weeks later, she's in the operating room. And she has the surgery, and path from the surgery is negative. And yes, then she comes out and she says, I still feel something. And they're going to evaluate her in 3 months because she's just had all of this massive surgery. They know they have a negative MRI. They know they have negative pathology.
But at that point, when she says, I feel something, how long had it been since her last PET scan? Because we know that's the gold standard, right? That's going to pick up anything.
I don't know that it's a PET scan that's gold standard or if it's MRI that's gold standard.
MRI is nowhere near PET scan. So when was the last PET scan?
In March of 2015, right before she came to see us.
So is there any reason why a PET scan wasn't done at that time?
Well,
rather than wait 3 months to see, let's see if you still feel something. I mean, this is somebody who is positive for cancer. So if they say, I still feel a lump,
but
I feel something,
right?
It seems to me that you should do the most you can to see what's there.
Without getting too far into the weeds with my red light on, I'm happy to answer your question.
I control that red light, so you get
okay, I'm going to ignore the red light.
Okay.
And I'm going to answer your question. So when 10 days after the completion mastectomies, the patient is in the surgeon's office and she says, I still feel something. And the surgeon palpates and says, I don't feel anything, but you're 10 days post-op. A few days after that, she's back in the oncologist's office and she says, I still feel something. The oncologist says, you know, I can feel something, but the oncologist testifies, and it's in her notes. We had a negative breast MRI. We have the pathology back from your surgery. It's totally negative. You just had all of this surgery, not to mention all of the surgeries before. She thinks it's probably scar or something going on from the surgery, and so she says 3 months. But even if, Your Honor, I have to go back to this, even if that was a mistake, even if that was a departure, she's stage 1A on that day, according to the plaintiff's own expert. She is stage 1A. And there is nothing in these pages and pages of expert opinion that tells us when that changed, including the day that her next biopsy comes up positive in February of 2016. It's the Foster case, Your Honor. They don't tell us. This is a sad case.
I got it. We will consider it. It's unfortunate that so many medical decisions are made based on what insurance companies will pay for.
Oh,
but a $2,000 PET scan might have given this woman a couple of extra days.
Well,
Thank you so much for your argument. We learned so much.
Thank you, Your Honor.
Thank you. Justice Kern, you may come back in. Muroff versus,
That was what we just heard.
is that what we just heard? Sorry. In IBM versus Global Foundries.
Good afternoon, Your Honors.
Good afternoon.
Robert Atkins. I represent the plaintiff appellant, IBM. The question here, at least for us, is whether a factual representation by a company about its current business plan and corporate strategy can suffice to be a present material fact for purposes of pleading, because we're here just on the pleading.
It's an
for
entirely-
pleading fraudulent inducement.
Counsel, what I don't understand is, it seems to me that the issue about their intention to be in the business of developing and manufacturing semiconductor technology for the high-performance market was critical to your deal. So why wasn't an allegation or representation about that included in the contract?
Well, there was discussions, due diligence,
No, I understand that.
meetings,
I understand,
plant visits.
I understand about the discussions and the representations, but if that was so critical to this deal, why wasn't that included in the contract?
Well, we'll pursue that in discovery, I suppose, but I would add that even if there had been a representation and warranty, that wouldn't preclude a fraudulent inducement claim either. So it's obviously it's a fair question to ask, but at the pleading stage, whether or not there was a representation, or in the Graubird case, there was a clarification in the writing of the misrepresentation before the contract, I would submit the question here is, can a business plan, a representation of a corporate strategy, be a present material fact?
Well, let me ask you another way. Because we know that oftentimes these claims are dismissed on the premise that they are duplicative of a breach of contract, that the damages being sought are the same as that of a breach of contract. Could you please explain why this is different?
Well, it's different because the claim is different, and then I'll talk about damages. The claim is different because there would be no contract, and there would be no breach of contract if there hadn't been a misrepresentation before the contract.
And you wouldn't have spent, $1.5 billion.
I'm sorry, Your Honor.
And you wouldn't have spent $1.5 billion.
Right, there wouldn't be a contract. IBM wouldn't have transferred its assets. It wouldn't have paid $1.5 billion and done a whole bunch of other things.
So that we're clear, right? So this contract basically had a portion of IBM's business in manufacturing these chips. And it was the business decision of IBM that it would be more conducive to your business to have another corporation do that part of the business, producing these high-level chips, correct?
More than that, not
Okay.
just simply a supply agreement, but a partnership for 10 years
Right.
to jointly develop, to research.
And to do it for the whole market, not just for IBM.
Correct.
Okay. And in order to accomplish this, because this is one of the few deals I've seen where you give over part of your business and you pay for the privilege of doing so.
Well, IBM
Right?
made a contribution of assets and cash
Call
into,
it what you
into
will.
this venture.
You were out $1.5 billion to make sure that this new entity would continue and develop this chip business. That was the entire premise of the deal.
Yes, that they would honor their contract to be part of a 10-year partnership because they were going to get into the market,
Right.
which they hadn't been in, and that's what's critical. They made chips for cell phones and car dashboards, and we said, wait a minute, we want to know if this is the business you're going into. It's like going to General Motors to get a fleet of cars, and General Motors says, yeah, we'll supply you with electric engines. And we say, well, You've been making great combustion engines for a long time. And the guy from GM says, the CEO, the CTO says, that's our business plan, that's our corporate strategy, that's where you're going. Come visit the plant, come kick the tires, let's have meetings. That's what we're doing.
I love that analogy. So GM is now saying, yes, absolutely, come on board. We're going to put out a fleet of electric vehicles, right? And stop with our dependence on fossil fuels. Kind of akin to what was happening here, right?
Right.
You branch out from your cellular business and now create chips at a much higher scale, much more powerful. They are able to power mainframe computers all over the world.
Absolutely.
And for that privilege, you provided all of your plant equipment, all of that technology, plus you kicked in $1.5 billion for that. And then they stopped doing the business. Am I right?
You're right, with one big hole in that, if you will.
Go ahead, tell me.
A contract. So we have a negotiation. GF says, I want to do this. I want to be in a partnership with you. I want you to give me the assets. I want you to give me the money. And we say, wait a minute. We want to know this is what you're doing. You're going into this business. They say, yes, we are. That's a lie. We now know that was a lie because they admitted they never planned to do it. That's the claim. Now, let's not overlook the fact that that was inked in contracts, multiple contracts, lots of provisions, lots of requirements, lots of obligations. The fact that to sit here and minimize that there were heavily negotiated contracts, which they breached, which they dishonored, is no small thing. It doesn't change the fact that there wouldn't have been any contracts. We wouldn't have parted with the assets and money had they not misrepresented their intention at the start. That's a fraudulent inducement claim. Whether or not the evidence will show one way or the other, that's for another day. I think the cases that have been decided before in this court, at the Court of Appeals, Graubert, Sabard, with all respect, Justice Oing's decision in the White and Davidson case, which was a denial of a motion to dismiss, a very similar concept, claim, and affirmed by this court. And what Justice Oing said, I thought was so appropriate at the trial court level. What he said is, this isn't about the contract. This is what was said before the contract. And in his opinion, he was speaking in the voice of the plaintiff. He said, I heard that grand things were going to be done. Records were going to be promoted. Radio tours were going to go on. That was outside of the contract. That was, in Justice Oing's words, collateral to the agreement. That was sufficient to survive a motion to dismiss. He was affirmed, and I think the same thing should happen here. I think this claim should be permitted to proceed to discovery, to evidence, and to trial if necessary. But at this point, we have stated a cause of action on the facts alleged.
Thank you.
Thank you.
Counsel?
May it please the court, David Lender for the defendant respondent, Global Foundries. The court below provided 3 separate and independent grounds for dismissing the fraud claim, but to affirm, all this court needs to do is apply this court's holding in WT Holdings, which is a case where Justice Manzanet was on the panel. In WT Holdings, the court found that a fraudulent inducement claim was barred by an agreement, just like the agreement here, which contained a general merger clause, but also...
Hold on a second, counsel, I got to ask you a question. I don't think those facts are something akin to the facts we have here, because this is some unique fact pattern that I read, because when I was reading it, it caused me pause. IBM was in the business of producing chips. They outsourced all that production to your guy. They changed their business model totally. I mean, they went from doing one thing to another to having you taking over the business. And then to make matters, well, I guess, to rub salt in the wound, you take all the assets that they transferred over to you and you sell it for $1 billion on the market outside to somebody else. So those kind of facts are very different from a lot of, and I was reading a lot of the fact patterns on all these other cases. It's very unique. It's like
Your Honor, let me just...
Yeah,
perfect
WT
storm.
ain't the same.
It's not the same.
Not by a long shot.
Let me try to explain why I think it is, and also why the contract, which is very important to understand.
Let me tell you about the contract. What the contract is, when I'm reading the contract, those clauses, the merger clauses and all the integration clauses, they're within the four corners of that contract in terms of terms and what people meant, you know. But when you're talking about we're talking about a company, and no small company, changing the direction of its business model because of something your client said. That's not part of the contract. And as Justice Gesmer said, you know, something like that should have been in the contract, but it's not. So this is what we're dealt with at this point. So why isn't it collateral then?
So just knowing, let me tell you why it is collateral, and if you look at the contract, it'll explain exactly why. The alleged commitment, the alleged representation that we were said to have made, remember this is before the contract is entered into, is that we're committed to the development of high-performance chips. That is the representation, the commitment that's alleged. That's in paragraph 6 of the complaint. But look at what ended up happening. Then the parties sat down and negotiated a fully integrated contract that set forth exactly what our obligations were, how much money we had to spend, how much resources we had to devote, what we had to do. And here's the
Counsel, your people did not honor the very essence of this contract, is the bottom line.
Your Honor, if we did not honor the essence of the contract, that's a breach of contract claim, which is what we're litigating down below in the Supreme Court.
Except that the damages here are different, because they gave you, on top of their business and all of its assets, $1.5 billion for you to develop that company. And instead, you sold the assets for $1 billion.
Your Honor,
there is no question that there's an issue here. No question that it is properly pled.
Your Honor, let me say 2 points in response to that. One is they're seeking the same $1.5 billion as their contract claim. Secondarily, let's not forget, the contract has a clause that recognizes that we may not be successful in developing these chips. If you look at section...
Not being successful and not even attempting success at a business are two very different things. There's no way, counsel, that a company could be successful unless they actually attempt the venture. And when you pull out of the business, you cannot possibly be successful in the business.
Your Honor, but if you look at the complaint, they don't suggest that we did nothing. What their allegation is...
Counsel, you sold the assets. Are you building chips?
Oh, of course, Your Honor. We are. We're selling chips.
The chips that the 7, the 10, no, you're not.
Your Honor, we are selling the 14 high-performance chips.
You're not selling the 7 or the 10.
Correct.
Which was part of the negotiations.
Your Honor, correct, but this is a fraud claim, not a contract claim. And the issue is did we commit fraud?
The issue is whether there is enough in the pleadings to withstand a 3211, right?
Correct, Your Honor.
Okay.
And that's right, and Your Honor, and the point here is that how can there be a fraud claim for the failure to develop chips when the contract expressly says and recognizes that we may not be successful in that development work? And
again, your use of the word successful is a very interesting way of using that term, because you actually have to be in it.
But Your Honor, that
you
is...
have to be in the game of producing them to say that you're successful or not.
But Your Honor,
so I'm not hearing you when you say we weren't successful when you didn't even produce them.
But Your Honor, that's not the allegation. The allegation is that we made a commitment to develop the chips. That's the allegation, that we were going to be in the business of developing these high-performance chips. Developing, Your Honor, that's the allegation. If you look at paragraph 6...
Counsel, isn't the allegation that you never did that you never intended to do it, you never planned to do it, you never tried to do it or unsuccessful, you never had any intention of doing it, and that's what brings it into the world of fraudulent inducement rather than breach of contract?
That's right, Your Honor. If the allegation in the complaint was that we made the representation that we were going to be in the business, we were going to try to develop the chips with a preconceived, no intention of doing it.
They're claiming you never intended to do it, and you never did do it, and you never tried to do it.
But Your Honor, that's not what they allege in the complaint. What they actually allege in the complaint, just so we all have it, what they're alleging in the complaint is that we tried to develop these chips for 3 years. And it was only after 3 years of trying and being unsuccessful in doing it is when we pulled out.
And that statement is based on your allegations that have not been tested. There's been no discovery. Again, this is a pleading stage.
No, Your Honor, this is based, I'm sorry, Your Honor, this is based on their pleading.
Counsel, their allegation is that 2 months after the contract was signed, you made clear that you weren't going to do it.
Your Honor, I would ask you to look at the complaint, paragraph 153, at record 229 to 230. This is their allegation. And what their allegation there says, that Global Foundries made the decision to abandon the development of the 7-nanometer high-performance chip technology in 2018. 2018, after it had tried for 3 years. And the reason, I'm sorry, it's complaint section 163 at record 231. And the reason why we ceased performance after trying for 3 years was because of careful consideration of business opportunities and financial concerns. It's the opposite of those cases.
What about the 10-millimeter chip?
I'm sorry?
What about the 10-millimeter chip?
What ended up happening, Your Honor, is we shifted from the 10 to the 7-nanometer chip, which we were allowed to do under the contract.
Is that what the discussions were that you had with them beforehand, that you were not going to do every minute try the 10-millimeter chip?
We early on shifted from the 10-nanometer to the 7-nanometer in discussions with IBM as we were allowed to under the agreement.
Thank you.
Thank you.
Counsel, you've got 2 minutes.
Thank you, Your Honor. Thank you, Your Honors. Let me pick up where he left off. The language he read was a quote from them, not an allegation from us about why they stopped after 3 years. The allegation from us that matters is paragraph 164 that says, on the very day they announced they were walking, abandoning us, abandoning this product market, the CTO, Chief Technology Officer, said, Global Foundries, their words, never planned, never planned. That's the claim. As to the WT Holdings case, that makes our point perfectly. What was the kind of merger clause in that case, and I'm reading from the case, was a disclaimer of liability. It was a release, not a no reps clause, not a complete agreement clause. The Court of Appeals has ruled 4 times, Ernst, Sabo, Dan & Realty, City v. Paplinger, General, Boilerplate, Blanket, pick your synonym, form merger clauses do not preclude fraud in the inducement any more than the parole evidence rule. Last thing I'll say, this reference to the agreements only obligating them to try, first of all, that's a question for trial, but it's false. What he's referring to is a provision of an agreement called the Technology Collaboration Agreement or Cooperation Agreement. It's attached to the pleading. Paragraph 3.1, what it says is if they fail to meet a milestone, they don't get it done by deadline 1, that's not a breach because we'll pick deadline 2. Not if you blow the deadline, you can walk away and we have no remedy. It's we'll give you room, not you try, if you fail, you're off the hook. It's not a best efforts agreement. It's not a commercial best efforts. They breached it, but in any event, that ain't a defense to a fraud in the inducement claim.
Thank you so much.
Thank you.
Ramroop versus Stein. That one's submitted?
Yeah.
Oh, excuse me.
Ozimek.
Ozimek versus DeJoseph. Thank you.
Sure.
Let's wait for your adversaries to get up here. Whoever argues first should come up. Okay. You may proceed.
Thank you. May it please the court. Andrew Bluestone for appellant. This case, this complaint demonstrates that defendants secretly, without consultation, without permission, and without any reason at all, discontinued against a physician who was implicated in the expert report
Counsel, let's focus on the issue of proximate cause, since that seems to be the major issue. Isn't the standard you have to show, but for the alleged actions, your client would have been successful in recovering in the case?
Of course.
Okay, so in this case, since it's a medical malpractice in the underlying case,
Yes.
you have to put forth evidence or make allegations that but for their actions in discontinuing the case, you would have actually been successful in the case.
I'm sorry, I missed the last 4 words.
But for their actions, you would have been, your client would have been successful in the case.
Yes, of course.
So I see a lot of things being alleged, but I don't really see anything about being successful in the case. For example, you look at the expert affidavit in the underlying case. It doesn't say we would have successfully stated a claim against this doctor who was discontinued against, but for the discontinuance.
I believe it does, although it says.
But no, what does it say about that particular doctor who was discontinued against, as opposed to the case as a whole? What are the actual allegations about that doctor?
So this doctor who was discontinued was a radiologist. The expert opinion says, and by the way, the radiologist, of course, made films and read the films. Paragraph D on page 90 of the record, it says, in my opinion, the films were not properly read.
Does it say that he departed from good and accepted medical practice in the way he read the films, which resulted in injury to the plaintiff?
It says further, and I believe it does, the radiologist did not provide the proper care. They failed, the radiologists in plural. They failed to follow up on this patient. The designation of the mass.
So where's a specific allegation about this particular doctor? Because that's very generalized to say the radiologist failed. Doesn't there have to be a specific allegation or specific showing that something this doctor did departed from good and accepted medical practice and practically caused injury to her? And I don't see that in the affidavit.
If we were at a summary judgment in the med-mal case.
No, you have to at least allege it, though. Where is it alleged in the complaint or the expert affidavit?
I allege that the expert affidavit implicated this doctor.
That's a very nebulous term, implicate.
I allege that this expert affidavit says that he departed from good practice.
We can read the expert affidavit, though, right? We can look at it, and I don't see where it says that.
This is not the summary judgment for the med-mal case. This is the evidence that was brought together by these attorneys representing the plaintiff. I can't go beyond what they put together in order to, at the pleading stage, have an expert medical opinion that this doctor departed from good practice.
Let's go to the complaint then. Let's put aside the affidavit and let's go to the actual allegations of the complaint. Where in the complaint does it say that but for the discontinuance, judgment would have been entered against this particular doctor?
Well, I have to reason because there's no way of saying that factually. But what I do reason is...
And how can you make out a med-mal claim or a legal malpractice claim?
The way I do that, Your Honor, is by showing that there were a number of physicians who were sued and that every one of them contributed to the settlement of this case.
Let's go back to the first question I asked you, which is that don't you have to show in a legal malpractice that but for the underlying malpractice, which is a discontinuance, they would have been successful in the action, not that they might have got a settlement from someone?
Yes, of course I have to show it.
Isn't that all you allege, that they might have got a settlement from this doctor if they hadn't discontinued?
I allege that he was the only doctor who didn't contribute anything, that he was let out with no reason, and that he had insurance, and that every other doctor put in money to resolve the case. However, I don't have an expert opinion that is ready for trial yet. We're still at the complaint.
But counsel, that's the point. I'm looking at the complaint. I don't see anything that makes an allegation that Dr. Kulkarni departed from good practice in a way that caused injury to your client.
I do.
There's nothing there that says that.
Do I not reference the expert report which implicates the radiologists? I do. Do I not reference?
But if part of the basis for that is that the radiologist didn't follow up with the patient, I don't know any radiologist that does.
No,
a radiologist conducts their study, gives their report to the treating doctor, and it is the treating doctor who then moves forward.
And that's what their defense is, that they told the patient, and that's enough. They didn't tell the treating doctors, and the expert report says that they didn't tell the clinicians what the clinicians needed to be told. And that's what Dr. Kulkarni failed to do.
But going back to what both of my colleagues have alluded to is, in order to establish a legal malpractice claim, in this case, you have to establish that there was a viable medical malpractice claim, correct?
At this point, I only need
Counsel,
allege.
wait. For us to say a lawyer didn't do a good job on a potential medical malpractice case, we have to believe that there is a viable medical malpractice case against this doctor, not based, counsel,
Yes,
on
you're right.
medical malpractice cases. We know that the typical thing that happens is you sue every doctor on the chart. And then as discovery happens, you figure out who actually had a hand in the care that deviated. So the fact that he was named doesn't mean that he was liable.
But he was said to be liable in the expert report.
Okay.
Now,
Oh, you're out of time. You'll have time on rebuttal. Counsel, 3 minutes.
Good afternoon, Ben Oxenberg from Furman, Kornfeld, and Brendan on behalf of the DeJoseph respondents. If it pleases the court, the decision below has to be affirmed because, as I think that the court highlighted, proximate cause and damages are impermissibly speculative, and additionally, the underlying action against this particular doctor lacked merit. His involvement was extremely minimal. He read scans in March 2007, saw something concerning, and wrote 2 letters to the appellant urging her to immediately come back for follow-up care. By the time she did come back, this doctor had already left the practice, and that is when the medical malpractice occurred.
What was the delay in coming back?
That I'm not sure of. The doctor did everything that he could to urge this patient to come back. He wrote 2 letters, and by that time he had left the practice. The subsequent doctor, that is when the medical malpractice started. He ordered new scans, said everything's fine, and come back in a year. She comes back a year later, the same thing happens. So her treatment is delayed by 2 years because of what these subsequent doctors did. And I don't think there's any ambiguity in the expert report. The expert concludes that the subsequent doctors were the ones that engaged in medical malpractice. He, excuse me, does not, he doesn't identify Dr. Kulkarni in the report. Excuse me, she doesn't identify Dr. Kulkarni in the report and doesn't say that Dr. Kulkarni was a substantial factor in causing the injury. The proximate cause and damage allegations are also too speculative. In the complaint, as I think was highlighted, it says that all of the recoveries were only potential losses. That doesn't satisfy the standard in a legal malpractice case.
Thank you.
Thank you.
Counsel?
Thank you. Good afternoon. Matthew Kelly Flanagan for the respondents, Mitchell Ashley and the Ashley Law Firm. Just to reference, Justice Kern, you had mentioned the but-for causation requirement. They have to show that but for the malpractice, the plaintiff would have recovered in the underlying case. And that's got to be done by specific factual allegations. And that was not done here. But even beyond that, what is in the amended complaint indicates that there is no case against Dr. Kulkarni, who was the doctor that was discontinued against. If you look at page 23 of the record, paragraphs 13 to 15 of the amended complaint, it talks about how Dr. Kulkarni reviewed the mammogram in March of 2007, sent 1 letter to the plaintiff to come back, and when she didn't come back after that, he sent another letter to her to tell her to come back. She finally comes back in July of 2007, and by then, Dr. Kulkarni is no longer with the practice. And we know that from the Second Department decision in the underlying case, which, although it reinstated the complaint against him based on the statute limit or the continuous treatment toll, it only found that there were statute of limitations was not a viable defense to him. But it was clear from this amended complaint that this doctor did what he was supposed to do, which was request the follow-up visits. And by the time she came back, he was no longer there. It was only a couple of months later, but he had left the practice by that point. So I submit that not only is there no allegations establishing but-for causation, the allegations in the complaint establish that it does not exist. If there are no questions, we'll rest on our brief.
Thank you so much.
Thank you.
Counsel, you have 2 minutes.
Yes, Your Honor. As you were discussing earlier, 2 cases ago, when you were talking about the failure diagnosed cancer case, just telling the patient is not enough. You have to tell the treating clinicians. Had the second radiologist who followed been told that this finding was there, had it been in the notes, had a letter been sent to the clinicians, it would have been a different outcome for this lady. That's the allegation in this complaint.
We don't know that.
That's the allegation in the complaint.
We have no idea. If she ignored him, how do we know that she wasn't going to ignore the other doctors?
She went back. Of course she didn't ignore them.
Well,
She went
she
back,
didn't
was
go back
treated.
immediately.
She went back when she was told basically she should go back. She went back and she had surgeries and she died. There's no question about that, Judge.
She
And
received 2 letters, counsel, right? Are you denying that?
I'm not denying it, but
Okay.
sending her a letter is not doing his job pursuant to the expert report.
So
in
what
this
was he
case.
supposed to do?
Tell the
On top
clinicians.
of the 2 letters?
Put something in the file about it. Tell the clinicians that he had this finding. He didn't.
Are these, I mean, how many years ago was this? I know that today we have all of
2007.
we have everything uploaded onto a
2007, Judge.
Okay.
And the expert in her report said that the clinicians should have been told.
Counsel, let me just, I'm sorry, one more. So in the first part of your argument, you said that your expert attributed some of the damage to Dr. Kulkarni. I've just reread your expert's report, and I don't see any mention of Dr.
Three parts where it is. In paragraph D, it said, in my opinion, the films were not properly read. She's talking about all of the...
No, but that doesn't specifically say anything as to Dr. Kulkarni, right?
He's one of the 2 radiologists who read the records, and she has his films listed up in the paragraph above. So yes, she's talking about him even if she doesn't say his name specifically. On the next page, G, the radiologist did not provide the proper care. They failed to follow up with this patient. The designation that the mass calic, and it goes on. And then in paragraph I, the providers were negligent, in my opinion, as this patient required a right breast surgical biopsy at the very least. And this does not comport with the minimum standard of care for clinical presentation of this patient for the radiologist, including Dr. Ratnarthanan and the first radiologist, Kulkarni. And finally, on paragraph 12, the applicable standards of care for a board-certified diagnostic radiologist, such as Dr. Ragatham, but also our guy, upon reviewing is, and it goes on. So yes, they definitely talked about about this guy.
Just to clarify one thing, in terms of the affidavit, it refers to the radiologist, but they're not 2 radiologists here. There are 3 radiologists involved. Is that right?
I think that there are, but this guy is one of the 3. She faulted all of them, all 3, all 2, whichever it is. He's faulted.
No, but it's not whichever one. I mean, in fact, there were 3, correct?
I'm not sure. I think there were, but I'm not positive.
Okay.
Thank you.
Thank you.
EMFT versus New York City Department of Transportation. You may proceed.
Good afternoon. May it please the court. My name is Evan Krinick, and I'm here today on behalf of Broadway 371 LLC. It's really the limited relief we seek here really ought not to be all that controversial or that complicated. There's a right-of-way easement that all the property owners share on this alleyway, and we don't seek to enforce the easement. We simply seek a declaration of what everyone's rights are in regard to this easement, so that people can understand their
Let's get right
rights.
to the first, one of the first issues, which is standing. What is the basis for your standing to seek this declaration?
Well, the question for standing is, does a party have a stake in the action? Do we have a genuine stake in this action, or are
we
we
know
some
what standing
stranger to
is.
it? So
We
our
want to know what your
stake in this,
standing is.
our stake in this is that we are obviously the prior owner of the condominium that was built.
The
We had
prior
a-
owner?
That doesn't give you standing.
Not yet. It doesn't yet. We had standing when we were the owner for sure. Then we represent in our offering plan what we understand the easement to provide, what the rights are. And then we issue deeds stating what we believe the easement gives rights to the people.
It
selling the
sounds
property.
like you're looking for an advisory opinion in order to avoid litigation against you for failing to give what you promised in your offering plan.
And that would absolutely give us a stake in this action in order to find out what the rights.
Not until there's an issue.
Well, there is an issue here. Let's be clear. Let's talk about that. There is an issue here. One of the property owners at page 300 of the record clearly states, I have an uninhibited right to park my vehicle in the alleyway, even if it blocks the one entrance, the north side, which only one vehicle can sit there. We have a different view that you cannot park your vehicle to impede that entrance. So there's an
But
actual
you're not
dispute
an
here.
owner.
View doesn't create a dispute. Just because you disagree doesn't, if there's nothing at stake, what is it that's at stake here?
What's at stake is the parties need to know, that's what a
Do we have a car that is permanently blocked and parked in front of this garage opening?
permanently blocked? That's a question, there's two stages.
Counsel, the answer to that question is no.
Of course not, of course
Okay,
not.
so then that's.
I thought that was
that's the
rhetorical.
That's the answer I expected from you.
I'm sorry, I thought that was, clearly there's not a permanent blockage there, but I think we have to, there's two aspects to an easement dispute. One is, what are the rights and obligations of the party to the easement? Once you establish that, the second part of it, which we're not here to talk about, is whether somebody's interfering with that. But you need to understand what the rights are,
Counsel,
what
we
the
don't give
obligations are.
advisory opinions, though, which is what you are seeking. It sounds the way you're framing it, at least here, that you're seeking a classic advisory opinion. And this court does not give advisory opinions. There has to be a justiciable controversy, and you have not yet articulated what your justiciable controversy is in this case.
It would be an advisory opinion, for example, if everybody had, the easement was there, and nobody took a different position as to what the ingress and egress meant to the easement.
There would be no need for an advisory opinion in that circumstance,
There'd be no
sir.
correct. But here, we have a sharp dispute between the parties as to whether.
Apparently not, because I don't have a plaintiff who's an actual condo owner before me.
You do not.
They would
That
have
is true, but
standing.
They have standing.
yes, they do. But I don't think that precludes.
Your future
Standing.
concerns about litigation, again, about not being able to deliver on what you promised in your offering plan, is not
Well,
a justiciable controversy here at this point. When a owner of a condo sues the sponsor because they believe they haven't gotten what they were offered, now you have standing.
But respectfully, I believe the point of a declaratory judgment action is to avoid the problem before the wrong happens. We shouldn't have to wait for.
Oh, I wish that were true.
Well, the case is,
But it's not.
Your Honor.
It's not. Every DJ action I have is after the controversy has started, sir.
Respectfully, the cases say otherwise.
Counsel,
And the classic
you
declaratory.
can argue what you like.
Yes.
As you saw from the laughter on this bench, it is obvious that that is not our experience, okay?
I have another question, which is this. It seemed to me that you tried to address this by claiming that your client had a right to 2 parking spots.
Correct.
But I couldn't find anything in the record that gave your client a right to 2 parking spaces.
Well, the plaintiffs pled in their complaint that we have 2 parking spots, and we admitted that in our answer. So I can give you those citations to the record. So I don't think that's a disputed fact anymore. They pled in the complaint that Broadway 371 is licensed to parking spaces. They pled that at page 25 of the record. And I'm fairly confident in our answer at page 49, we admitted that allegation as to 371 Broadway. So I don't think that's disputed fact. Now, we have parking spots there. People who park there have to use the easement. So that, again, would give us an interest in how this easement is to be articulated. But again, this has become complicated, perhaps. I disagree on justiciability. The courts, obviously, I've seen many DJs where people bring declaratory judgment, especially the insurance coverage aspect, before there's a dispute in order to determine what the rights and obligations of the parties are.
No, the council, they only bring it once it's an issue as to coverage because there's an underlying personal injury action that's already commenced. And the equivalent here would be if there was a lawsuit against you from the co-op, the dispute has begun. You don't have that equivalent here.
But here, respectfully, my red
I'm
light
going
is
to
on.
allow you to respond to.
Thank you. We have a dispute here in the record by the statements of the parties that they disagree as to the easement rights that exist here. You can park in the north end where it blocks all ingress or egress permanently all day, as they said. We can park there all day, or you can't. That is a dispute. We think you can't. They think they can park there all day, block the ingress and egress, so their tenant can have his delivery truck there. I'm not talking about drops and stops. I'm not talking about temporary parking. That's a legitimate dispute. That's not hypothetical. That's not speculative. That's not may or may not happen. I don't think we have to wait for him to park there and then run to court and say, he's parking there. We need an action right now. We know we have a difference of opinion as to the rights and obligations under this easement. We should be able to come to court and get a declaration. You either can or you can't. This is the scope of the easement. This is the breadth of the easement.
I got it.
This is what
You'll
allows
have
people
time
to
on
do.
rebuttal, sir.
And I think we have time. Thank you,
Counsel?
Your Honor. Thank you.
Thank you. 3 minutes.
May it please the court, Avram Turkel, Borstein Turkel, PC, for plaintiff respondent EMFT LLC, who are the owners of the building located at the southeast corner of the Franklin Place private street. Plaintiff respondents respectfully request that this court affirm Supreme Court's decision in order denying appellant's pre-discovery motion for summary judgment, and further to search the record and dismiss appellant's counterclaim as a matter of law for lack of standing. Lower court made a decision on summary judgment. Supreme Court correctly held that appellants failed to eliminate issues of fact, including on standing, justiciability, and the interpretation of the easement itself. As the court rightly noted, the appellant simply does not have standing. They are not easement holders.
So which one of you had said in your pleadings that they had 2 parking spaces?
We all did, but what Judge Hagler...
So is that right or is that correct or incorrect?
Well, it may be correct that they have the parking spaces, but that does not make them an owner who holds the easement, which would give them standing. Remember, this is an express easement that says way of passage, and they're asking for the court to...
I understand. I suggest perhaps you might want to look at those pleadings then.
Well, even if they do
because you're saying, look, to the extent that they can argue, you admit I have 2 spots, right? And presumably by having parking spots, you are presumably entitled to be able to get out of those parking spots. You need to address that.
Well, that's not really the issue here, Judge. What the issue here is the determination of what the express easement says, a way of passage,
Counsel,
which
is
is
there
fact
another way
intensive.
out of this garage other than through that exit?
There are 2 ways out.
Are residents able to exit through the commercial side?
The commercial side, Judge?
I understand that the Broadway side was utilized.
I'm pretty sure there is a door on the Broadway side, but what the appellants have admitted...
Being a door into the building and having access for a car passage are 2 different things.
That's true, but the appellants have admitted that, especially with regard to my client on the south side of the alleyway, that parking does not create an impediment. So, one, there is absolutely an issue of fact that precludes, that requires affirmance of denial of summary judgment.
Right.
As to standing, which is what we're asking the court to further do right now,
right.
Only an easement holder can come to the court and demand a declaration concerning the meaning of an express easement. Thank you, Your Honor.
Got it. He left you 8 extra seconds.
Good afternoon, Karen Fryman, Stern, Tannenbaum, and Bell for Respondent 70 Franklin Place, LLC. I just want to touch on a couple of discrete issues rather than repeat anything that Mr. Turkel said. First, with respect to the parking spots, Justice Hagler below properly pointed out that even if they have parking spots, which there's no evidence in the record other than what might have been alleged in the complaint that they do or what rights it gives them or anything like that, they said in their appeal brief on page 24 that the sponsor's ability to drive cars in and out of the alley is irrelevant to the issue of standing. That's what they said in their appeal brief. A couple of other points, if I can make quickly, Your Honors. A minor point perhaps, but worth noting is that although there are two appellants, Appellant L. Odd did not assert the counterclaim here, so has no basis for this appeal. Their standing has been based on their claim that the Attorney General has investigated whether they made false representations to the condo unit owners, but there's only evidence that such an investigation exists is a letter sent on behalf of the condo owners in 2016. There's no evidence that the Attorney General ever did anything with that letter, that the investigation is ongoing, or anything else that makes it a live controversy. They similarly said...
Was there any, I mean, this is a pretty well-known street in New York City, and it would seem to me that if I owned property in this alleyway, that I would have been all about the business of knowing what was happening with this development and making sure that the way this development went up, what access it had and how it impeded use of Franklin Street would have been discussed as a community. Was that not done here?
My client was not consulted in anything having to do with the sponsor's development or sale of that building. And that may be caused some of the problems that are being faced now. But we had...
Now prior to this new development, did the prior development have its garage exit out onto Franklin Avenue directly?
No, to the best of my knowledge, there was no garage there.
So this is what I'm saying. So when I mean, typically, a new developer has to submit plans to the Department of Buildings for approval, et cetera. Are we saying that all of those neighbors had no access to that information, were not at all consulted in how this new plan was going to impact the neighbors and the people who had easement rights to this street?
To the best of my knowledge, and there's certainly nothing in the record to the contrary, my client, and I don't believe any of the other landowners were consulted at all about the development. And this is sort of related to a point that Mr. Turkel made that I'll reiterate, and that is my client, it may be helpful to look at page 294 in the record, which is the tax map, just so you can place everybody and where they belong. My client is Lot 1. Mr. Turkel's client is Lot 33. We're at the south end of the alley on the Franklin Street side of Franklin Place. And appellants have conceded over and over again in their papers below and in the appeal papers that they can get by our properties even if we park cars there. There's no dispute, there is no live controversy, at least with respect to my client. They have put in photographs to show that cars can pass, even if my client parks a car, even if Mr. Turkel's client parks a car.
Which one is Mr. Turkel? Okay.
The one who just preceded me.
Okay, thank you.
So there's absolutely no justiciable controversy with respect to us. They don't really claim one. Their papers, as I said, establish that there's no controversy. They concede that my client doesn't block the property. They say in their reply brief, on the first page of their reply brief, that owners at the south end, my client, where it is wider, may be able to park in a way which does not obstruct the easement. They also said that below. So there's no there. There is no justiciable controversy. And certainly, remember, this was a motion for summary judgment, Your Honors. Certainly, they didn't eliminate issues of fact as to their standing or as to the existence of a justiciable controversy. One of the other things, in fact, there's no evidence in the record that any party is improperly blocking or obstructing, and it's just as, thank you, Your Honor.
May it please the court, Your Honors, Michael Contos appearing on behalf of Respondent Cross Appellant 373375 Broadway LLC.
So is your client blocking the?
My client's at the north end of the alley, and yes, when my client parks behind their building, it does block the alley. The alley is very narrow at that end. If you look at our papers, Your Honor, we argue, we have some additional arguments other than the counsel has presented so far. One, we've been parking behind our building every day for 40 years. 40 years. And it likely before that.
So can you answer my question to prior counsel? In light of the easement that has existed in this street for over 2 centuries, and your client's 40 years of standard practice in utilizing his property without complaints from anyone, am I right?
We don't know that there were no complaints from anyone.
But they certainly weren't voiced to you.
Not to me.
Okay, to your client.
I'm not sure about to my client. They were not voiced to me, Your Honor.
Okay. And was there any community involvement at all in how this new development was going to impact the use of everyone else's easement?
To my knowledge, Your Honor, the developer was well aware, the record shows, was well aware of the conditions on the alley, meaning that people parked on the alley, other owners parked on the alley at the entire time they were developing this property, which they bought in 2012, right? They've sold all the units, so they no longer have any interest in selling units, as they say in their papers, but that's sort of beside the point. Their papers don't allege, and there's nothing in the record that shows they've ever been blocked from exiting their parking garage. They've never, and in fact, they never have been. They've never been blocked. They could always had access to a public street at all times, even when my client parks, as they've done for 40 years every day, they still can get out to the street. So
is it a two-way street or a one-way street?
it's, I'm sorry, which street, Your Honor, are you referring to?
Two-way or one-way?
Franklin Place?
Yes.
It's not a city street, it's a private alley, so I guess it's not. It tends to run, traffic tends to run from north to south on the alley.
Meaning from the blocked portion of the street into the main.
Yeah, so if the alley were open, which it's, again, not open very often, traffic would generally, I think, go from north to south.
So they can leave from the garage, make a left.
So they can make a left out of their garage at all times and get to the street. Yeah, they've never been blocked. And they don't allege that they've ever been blocked, so I don't see what the issue is.
And you're to the north of them?
We're on the
so
north.
that they would have to turn in your direction to get out?
No, they don't have to turn in our direction to get out. They turn left, south to get out to Franklin Street.
So why would you be a problem?
I don't think that we are a problem. That's what I'm saying, Your Honor.
Okay. All right. Thank you.
Thank you, Your Honor.
Explain to me the problem.
Yeah, it's an obvious problem. This is an alleyway that's 24 feet wide at its widest. At the north end, where the last council's client is, it's 12 feet. You put a car there, a bicycle can't get by. So yes,
come
you have
on.
access on.
Council, a bicycle, really?
I've been
How
there.
big is this bicycle?
I'm telling you, it's very, car is there, another car can't get by. I'm sorry to be sarcastic about it. If one car is there, you can't get another car by there.
Can you
Ingress
answer my question about what your developers and sponsoring defendants did
I don't.
to notify these fellow easement holders of how your intended use of the space would infringe upon their use?
Your Honor, I don't have that information. I've been involved in the case that long. I know the record.
That is the point, right?
Well, the Department of
That
Building.
is the point here. Because quite frankly, if you develop this building knowing that the former owners had entrance and access on an opposite direction that did not impede on that Franklin Street, and now you're going to change that without at all consulting your community, you're going to have a problem. You can't change something that has been status quo for 200 years and think because I put up a condo, I can change all that just because I feel like it.
Respectfully, Your Honor, the easement of ingress and egress to both streets is what's been in place for 200 years.
Right.
The only person that's changing that, that's what's been in place.
The former owners didn't use it in this way. Am I wrong about that?
The former owners allowed the person to park there as
The
an
former
accommodation.
owners, did they have a garage that emptied out onto Franklin?
They did not have a garage.
So they had no way of having the same issue. It was the placing of a garage opening on Franklin that created this issue,
Respectfully, Your Honor,
right?
I would disagree with that respectfully. If you have a truck coming in, make a
No, it
delivery.
doesn't matter whether, the issue is, how was this street used for 200 years? And now, because a developer decides I'm gonna put up a condo, and I don't begrudge development, trust me. I love development. I think it's great for our state and our city, okay? But you can't just trample on the rights of people who have an easement without some community involvement. Otherwise, this is where we end up.
I can't.
But we shall consider your papers.
Can I make one more point? I'm not
You'll get
snatching
30
defeat from
seconds.
joys of victory, but let me just make one more point on the standing issue, which I think may be important.
Okay.
If in fact we are being challenged by the board, the people we sold to, as to the validity of the representations we made, we need to be able to defend that accusation in some form, somehow. And in order to defend that accusation and prove that we're right, we need to have the people who also own the easement bound by that. We can't just defend it and say we're right and then we win, but they're not bound by any decision that's in some other lawsuit. So in order for us to defend our interests here, we need to be in a lawsuit that all the parties are bound by.
Counsel, you just made my opening point and question to you. Thank you.
Okay, Aaron, thank you.
Thank you, Your Honors.
Singer Equipment, oh, I'm sorry, you have an extra minute, I forgot.
Thank you.
Forgive me.
I appreciate it, and you're quite forgiven, Your Honor. I just wanted to bring up a couple of points that I didn't address in my opening argument. One of the things that we're asking for, the relief we're seeking, is that you reinstate the punitive damages claim of respondents in this case. There's plenty of record evidence to show that there was malicious intent, wanton and reckless behavior with respect to our rights. They spent hundreds of thousands of dollars lobbying the Department of Transportation to have them stop block parking on the street. DOT did, and we sued them. That's how this case commenced. DOT capitulated and removed the signs. They then went and changed the grade of the alley so that water just pools against our client's building. We really think because there was no discovery on this issue, the punitive damages claim really should be reinstated and let that go to a jury.
Thank you.
Thanks, Your Honor. Thank you.
Okay, Singer Equipment versus the Chapin School. You may proceed.
Good afternoon, Your Honors. May it please the court, Wilbur Trevino for the defendant appellant. So simply stated, this case at first glance may seem a bit more of a head scratcher or a headache than the usual mechanics lien construction case. But it is our position that the well-settled case law allows for adequate guidance in the resolution in our favor. It is important for the court to understand that this case is not the typical construction case involving a standard construction contract with industry standard terms. Here we have a relatively modest contract between defendant respondent and its GC with respect to the project.
But your contract was with the GC, not with Chapin School directly, correct?
Correct.
Okay.
Correct, Your Honor. And so, at this point in time, it is undisputed that what we call the LOI agreement between the owner and the GC is lacking material and standard terms that are usually found in construction and standard construction contracts, such as the total price, which allows for a ceiling price of the project, such as the retainage provision, allowing whether or not the owner is entitled to withhold retainage and for a specific purpose, and whether and the circumstances under which that retainage will be released. So we don't have any of that here. And the trial court decision bypassed a whole well-settled New York law and public policy fundamental, which is parties are free to negotiate and enter into agreements of their choosing. So here we have clear and unequivocal contract, although it's pretty minimal.
Why wasn't Chapin entitled to withhold any further payments based on the lien waiver requirements, which provided that IBEX was to provide an executed lien waiver that had fully paid all its subcontracts, and it's clear that they didn't pay their subcontractors? Why wouldn't that be a breach of the letter of intent which would allow them to withhold further payment?
In terms of the obligation for them to provide a lien waiver form, is that what Your Honor is asking?
Based on their representation that they had fully paid all the subcontractors.
So that term in the letter of intent agreement is simply an obligation for them to provide a form, right, at the end of payment, not before. And so, okay, they have an obligation or a requirement that they agreed to that they're supposed to provide a form, but the terms of those forms are not incorporated into the overall agreement by reference. It's merely an exhibit. And to add to that, we don't really even know whether or not the defendant respondent and his GC actually complied with that requirement. Based on how this whole project unfolded, it would not surprise me that the informalities that the parties engaged in allowed them to just forego that requirement. At this point in time, we don't know whether or not lien waiver forms were actually given from the GC after every payment that they issued, that the defendant respondent issued. Defendant responded that did not attach any sort of executed lien waiver forms in support of its motion. And frankly, we just don't know at this point, Your Honor.
Hasn't discovery already occurred?
Discovery was very limited on the issue because Justice Sherwood wanted first to make sure whether or not a lien fund existed. Because if a lien fund did not exist at the time that Director Dorr, my client, filed its lien, then there's no need to continue with the case. Right? So I came into the case much later in 2018, so a lot happened before me. But nevertheless, from the point that I started becoming involved in this case, the Supreme Court allowed us to engage in limited discovery that would allow us to answer the question of whether or not a lien fund existed at the time that my client filed its lien. And it is our position that it did. $1.9 million constituted a lien fund of which defendant respondent improperly depleted and withheld.
Got it. Okay.
Thank you.
You have rebuttal time.
Good afternoon, Your Honors. John Wojak from Duane Morris for defendant responding to Chapin School. We're here today because Chapin's general contractor, as everyone agrees, absconded with over $2 million and breached its fundamental obligations to Chapin School and was properly terminated for cause. And never.
I agree with you. The question, though, is during the process of Because in construction like this, it's not one big lump sum that the GC gets. It's done based on work done over time.
Monthly
right?
requisitions, Your Honor.
And which is what was done here. So the question is whether there was any in the process that was built into the, you send us your invoice for work done, we send you payment. Was there any check process for you, for Chapin, to make sure that the monies you were sending to the GC were making its way down to these subs? Was there any kind of bookkeeping, anything that would have alerted Chapin, you know, I'm not sure this GC is paying the subs?
Your Honor, first of all, we did get monthly requisitions, and as part of the monthly requisition process, Chapin did look to make sure that it was getting a lien waiver from IBEX, the general contractor, saying that it had appropriately paid everybody and utilized the money from the last prior payment.
So that protects Chapin from, certainly from IBX, right?
That's correct.
But IBX is affirming something that the subs don't get a chance to weigh in on, right?
It's not appropriate in construction for the owner to reach out and contact directly the subcontractors, because that would be an interference in the contractual relationship between the general contractor and its subcontractors.
Okay,
So
certainly there's nothing that would prevent an owner who has contracted a GC from requiring proof of payment to the subs. I mean, a waiver is nice. It gets you out of any problem with IBX. But if the subs are being shortchanged, by the time you find out about it, as happened here, the GC has run away with the money, and now you have these.
Typically, what happens is, if the sub isn't being paid, they'll let somebody know, and they'll let somebody know quickly. This was not a long-standing problem. This was a month or two's problem.
Counsel, I have a question. Isn't there a retainage situation here too? I mean, when Chapin paid the GC, it retained some of the funds?
Yes, and that's what we're fighting about here.
Yeah, so that the retained funds, that funding that you retained, you end up having to pay that out to all the other subs that didn't get paid, right?
The retainage is also to be used to ensure that the project is completed. The retainage is there to fund not only paying people, but it's also there to fund completing the work because IBEX defaulted and did not complete its work.
And that's not, but the retainage here was not used to pay the subs for work done in the past. It was used to complete the work that Chapin says IBX did not do, correct?
That is
So what
correct,
ended up happening here is that we have subs who haven't been paid.
And that is correct. It's under the lien law. Under the lien law, a fundamental tenet of the lien law is that an owner is not required to pay more than they agreed to pay.
I get it. I mean, my concern, right, is that, you know, these subs are small, for lack of a better word, mom and pop operations. They are hanging on a shoestring. They are beholden to big GCs. And if within the contract, you protect yourself but not the subs?
They have a right as well to sue the GC, but unfortunately, in this case,
GC who's probably either under indictment or bankrupt.
That's exactly what happened in this particular case.
So that doesn't help the GC any, but thank you.
So,
I'll give you 1 more minute since we interrupted you.
So the termination was proper in that they breached the fundamental obligation, and even outside of the terms of the letter of intent, they have IBEX had a fundamental obligation under Article 3A of the lien law's trust fund provisions, a statutory obligation to properly use funds that were given to it. So there's no question that they were properly terminated. Judge Sherwood was correct in his holding. So the issue becomes the retainage itself, and even though the letter of intent may not have spoken to retainage or what could be withheld or how it could be used, a court is entitled to fill in from custom and practice and from what the parties do themselves and show an agreement, a custom of a course of business is entitled to fill in the missing terms, which is exactly what Judge Sherwood did. Judge Sherwood found that.
But why shouldn't a court likewise consider that that money should be used to pay for work already done?
Judge Sherwood found that under
Especially
Black's law,
since you didn't have any retainage language in your contract.
well, what Judge Sherwood found was that the basic Black's law definition of retainage is that it's money withheld as security until construction is complete and all liens are released or have expired. And Judge Sherwood found that since those conditions didn't occur, the retainage never became due. If it never became due and owing, Chapin is entitled to use it to finish the job.
Got it. Thank you. You have a minute on rebuttal.
Thank you, Your Honor.
You're welcome.
So, would like to address opposing counsel's claim that of the definition of retainage, right? So, New York lien law clearly states that a lien fund is instituted the moment that the lien is filed, when there are monies coming out of monies that are due and owing to the contractor if it's a GC who's filing the lien. We deviate from that standard analysis only if there's a material breach from the GC, if there's a provision allowing for retainage to be contingent upon the completion of the project, and or whether or not there's a provision allowing the owner to use such retainage for the completion of the project in the event of default. Here, the LOI agreement has none of that. None. So, as a result, these are experienced, sophisticated business entities. The tuition on Chapin School alone is about $56,000 a year, if I'm not mistaken. So, the fact that there's no provisions as to these things that would allow them to withhold the retainage that they claim, which we dispute because we just consider that money to be withheld monies, not even under the concept of retainage. They're just withheld monies. At the end of the day, no matter how you look at this case, there was a lien fund of $1.9 million that my client's lien attached to the moment it filed in May of 2016, 2017, if I'm not mistaken. I'm sorry if I got the dates wrong. But that's all I have, Your Honors. Thank you so much. And for that reason, we ask that the court reverse the trial court's decision and grant that there was a lien fund in existence.
Thank you.
Thank you.
Sen Park Realty versus Gurin. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court. My name is Solomon Zabrowski, and I'm here for Adina Marmelstein, the defendant appellant. If the court has any questions of me, I know you've read all the briefs, I'm ready to answer them. Right, then let me continue. We had a stipulation that was signed by and between the parties, and it's my client's view that the plaintiff respondent has not complied with the terms of the stipulation, which means
that they showed her 4 apartments.
there's no dispute that they showed her 4 apartments, Your Honor. We do not dispute that, no.
And she didn't choose to move into any of those apartments.
She did not elect any of those apartments, but this was during COVID, and it's also our allegation that 2 of the apartments were not ready to be moved in.
Well, I'm curious about that. The first of the apartments, Ms. Higgins stated in her affidavit that she told your client that the apartment would be renovated before they expected her to move in. And Your client, in her affirmation in opposition, did not dispute that Ms. Higgins told her that.
Not only did Ms. Higgins tell us that, but the attorney for the plaintiff respondent told us that. No, we don't dispute that either.
And the
What we-
same as to the fourth apartment.
That was only with respect to 2 apartments, Your
Right, the first apartment and the fourth apartment.
I'm not sure which order, Your Honor. But our allegation is that that doesn't comply with the stipulation. The stipulation provided that they had to show 4 apartments that she could choose without guessing what the apartments would look like. Were they ready to move in? No, they weren't ready to be moved in. Also, the stipulation, and I'm sure you know this, as for lighting in the new apartment, plaintiff will make best efforts to provide an apartment with approximately the same lighting in 16K, and they'll be shown 4 apartments on the Upper West Side with configuration similar to that of apartment 16K. So we allege that they didn't do either. They didn't show her any apartments of the same configuration, and they didn't use best efforts, to provide an apartment with approximately the same lighting in 16K. And, Your Honor, these 2 points were very, very, very important to my client at the time that the stipulation was signed. And I can say that without reservation because I was there. These were 2 issues that without those language, the stipulation never would have been signed. And they didn't use best efforts. In fact, they claim they don't have to use best efforts. And they didn't show her 4 apartments of the same configuration. No way, no how. So we're claiming they didn't comply with the stip, and we're saying that the stip didn't provide that she has to respond within a certain period of time also.
But you would agree that a contract has implied in it, where there isn't a specification of the amount of time, that the time be reasonable, correct?
Now, here's the issue. So I guess by analogy, can we use the word time of the essence? So if we use time of the essence, they have to provide a certain amount of time. They can't just say, well, you have a week to decide. No, they can't do that. They have to give a reasonable time. Now, what's the reasonable time? They never sent a letter saying, we're going to give you 30 days. We're going to give you 60 days.
They're supposed to keep an apartment vacant for 30, 60 days while your client decides whether the light is enough?
The 2 of the apartments couldn't have been rented. 2 of the apartments weren't ready to be moved in, Your Honor. And, Your Honor.
You can save your "and" for rebuttal.
Thank you very much.
Thank you. You may proceed.
If it please the court, my name is Mitchell Shankman. I'm from the Abramson Law Group. I represent the respondent in this case. First, to address counsel's comments,
I have a question about the reasonable time. In determining whether or not your client gave her a reasonable time to decide on each apartment, how should we consider, or should we consider, that there was an eviction moratorium in effect until January of 2022?
The reasonable time, the defendant did not make a decision at all. So saying she was offered 4 separate apartments, 2 of which.
Right, but I specifically asked you how we should take into account the eviction moratorium that was in effect until January, until
the moratorium, that would not stop showing of apartments. That would not stop allowing her to choose an apartment. It had nothing to do with that. The moratorium only would have affected the legal aspect of the case. But the big problem here, according to the defendant, was the interpretation of the stipulation, having nothing to do with the follow-up matters, which was all I believe after the fact, a rationalization as to reasons why she didn't want to make a decision. She could have said, I need to think about it. And she was asked, counsel asked her on numerous occasions, our office asked her, you've looked at the apartment. Do you have any idea? Is it a yes, a no, maybe? You want to think about it? She wouldn't respond at all. So after a while, it was taken as a no. And we did this 4 times. And then we even offered a 5th apartment to show her, and she didn't even want to see that. So this whole thing took, from the stipulation to the time we gave up and made the motion, it was 16 months. She was shown apartments over a year's period. I think a year's period is enough time, even if the apartment is not in perfect shape, to say, okay, I'll take this one. You, landlord, fix it up as you promised to me.
How many apartments were shown prior to the moratorium? Because the stipulation was May 2019.
Right, it was
the pandemic started really January 2020. We didn't go into lockdown until March 2020. So how many apartments was she shown before the pandemic hit?
She was shown one. She was shown one in October of 2019 and 2 apartments in June of 2020.
Okay.
And the 4th one in September of 2020.
Okay.
So, but she was shown one prior to it, and she was told as to that one, it would be repaired, it would have all new appliances, all new fixtures, everything new, and she didn't even answer. She didn't say yes and didn't say no. It isn't fair to her to keep the landlord waiting all this time.
Although I gotta tell you, I wouldn't give you an answer for an unfixed apartment either.
Well, if you don't like it, then just say no. It's just,
Well, you're not. To me, that's not a real option. I have to agree with counsel on that. Okay, to tell me you're going to, when you have it fixed, show it to me again, and then I'll tell you if I like it.
well, the stipulation also provided that she was to pick one of those 4. But despite that, they offered to show a 5th, and then after the motion went to Judge Tisch, I believe, in 2021, an idea arose to look at additional apartments, another 2 apartments. And the defendant never got back to us as to when she might be available to look at it. So then the judge said, enough is enough, I'm just making a decision.
Also, the two out of the 4 apartments that were shown to her that were not ready to be moved in, how not ready were they?
I'm sorry, I can't.
The 2 out of the 4 apartments that were originally shown to opposition, two out of the 4 apartments were not ready to be moved in. Is that correct?
That's correct.
Can you describe their state? What made them not ready to be moved in? Are we talking about that there were no walls? What condition?
Oh, no. It was just damage which needed to be repaired, old appliances which they agreed to swap out. They would paint, change carpeting. It wasn't like it was a bomb zone.
A bomb zone?
It wasn't a demo.
Really?
It just needed a renovation.
A bomb zone?
I'm saying it was not like a bomb zone.
Well, I would hope not. That a bomb zone wouldn't even comply with habitability.
Then you wouldn't be you would open the door and there would be nothing there. But in this case, there was an apartment there, and they offered, like I said, a 5th one and a 6th and 7th. Nothing came about it.
Okay, we got it. Thank you. Thank you. Counsel, you have a minute.
Your Honor, I don't believe that it was in the record that about the 2 apartments. In fact, later on, during our discussions with Judge Tisch, I don't believe that's in the record.
You're referring to apartments 6 and 7?
Yes.
But there is something in the record about a 5th apartment being.
Yes. But I want to acknowledge that that did occur during our discussions with Judge Tisch. I don't want there to be anything, but that hurt us because Judge Tisch got angry with my client, and he, in my opinion, he ruled against her because she wouldn't consider the apartment.
So you're telling us that in fact they offered to show her 7 apartments of which she...
No, they didn't offer. We were negotiating. There was a negotiation.
I see. So she didn't actually see a 6th and
No,
7th?
no, she did not. There was a
misunderstood what you
negotiation.
said.
But counsel said he offered to show a 6th and a 7th, and your client never followed up.
We did follow up.
You
We
said, I don't want to see it.
No, we negotiated, and what we said was, have them in the same building that she's in. If you show us another 2 apartments in the building that she's in, she'll look at those 2 apartments. We did say that, but there's 2...
Is that what the stipulation said?
No, that's
Okay.
not what the
So
stipulation...
you were changing the terms of the stipulation.
We were negotiating, Judge.
Counsel, you can't negotiate against the stipulation.
You're right, and we claimed that they didn't comply with the stipulation.
Got it.
But
You don't, stop.
No.
You don't negotiate against the stipulation.
There's 2 points I
Counsel,
wanna
no
raise.
more points. You're out of time.
No, it's answering
Counsel?
the questions.
Counsel,
Okay.
thank you.
Thank you.
Have a good day.
You too.
We will consider your papers and the record.
Thank you very much.
160th versus Zhao. You may proceed.
Good afternoon. May I please the court? Bishop Robert Liu with Balance Law Firm on behalf of appellant Mr. Lin and Qing Zhao. Your Honor, I want to address this court on 2 issues. First is the excuse of Mr. Lin's duty under the lease, under the doctrine of frustration of purpose and impossibility. And the second issue is lack of personal jurisdiction due to insufficient service of process. On the first issue, the lower court erred in holding that Mr. Lin's duty was not excused because of financial hardship or economic difficulty alone. But Mr. Lin's difficulty goes much more beyond financial difficulty and economic hardship. Mr. Lin and his entire family were the target and the victim of racially and ethnically motivated hate crimes that were committed against them. Mr. Lin...
You're not suggesting by the landlord. You're saying by people in general.
Right.
Okay.
This occurred during COVID.
Right.
So Mr. Lin is a recent immigrant from China, and the restaurant they are operating is a Chinese restaurant called Silver Palace Chinese Restaurant. And according to the first page of the lease they entered into with the landlord, the lease provides that on page 135 of the record, the lease provides that tenant shall use and occupy the demised premises for Chinese takeout and for no other purpose. So the only allowed purpose of this premise is to open a Chinese takeout. After the start of COVID-19, we have seen a troubling, sharp rise of racially and ethnically motivated hate crime committed against Chinese Americans or Asian Americans in general. And unfortunately, Mr. Lin and his family experienced one such attack at their very restaurant. One day, they recounted one such experience. A group of toughs rushed into their restaurant and vandalized the entire restaurant and physically assaulted Mr. Lin and his wife and took away all the things that they think of any value. And the more troublesome is that their 2 young daughters were also present at the restaurant, and the 2 young daughters also witnesses this entire attack. And their two young daughters had to be at the restaurant because the schools that they were attending were closed, and there was no other child care facilities available at that time because everything was shut down by executive order. So that's a very unfortunate situation. So at that time, Mr. Lin realized that he was putting his own life, his wife's life, and his 2 young daughters' life on the line by keep operating this restaurant. So this is not just a matter of making less money. This is truly a matter of life or death. And there's no, and they don't think that this will be the last time they were attacked, just given the general social environment at that time.
Counsel, I cannot begin to tell you how much we regret that instances like you have described have occurred in our country, throughout our nation, and it is unconscionable. So we agree with you, and we empathize with your clients, their families, and those 2 young daughters. But that is not the fault of the landlord. The landlord did not bring this upon this family. They too, like all of us, have been victimized by this pandemic. So for us, with all the empathy that we may have, and we have it, okay? We cannot ignore the confines of the law that we have to operate under. And I say this because I suspect your clients are watching, and I want them to understand that their plight and their concerns are not falling on deaf ears on this court. But I must follow the letter of the law and the 4 corners of that lease agreement. You understand?
Yeah.
So when you have rebuttal time, I want you to address those issues when you come back up, okay?
Okay.
Okay. Counsel?
May it please the court, for the respondent, Dean Dryblatt from the firm of Rose and Rose. I wish to just make 3 brief points. Number 1, procedurally, it's important that this comes in the context of a 3211A7 motion, where whatever how sympathetic one views this argument, it's inappropriate. The appropriate test is whether or not the complaint on its face states a cause of action, and if that's the case, that's it.
Right, I agree. Can we start, since one of the second points counsel was going to address was the issue of jurisdiction. Can you start there with how service was effectuated and why that was proper for the court to obtain jurisdiction over this case?
Yes, at the time service was effectuated, the leasehold, as the record shows, they were still in possession of the premises. The leasehold had not been surrendered. The leasehold was not surrendered until right after the summons and complaint were served. In fact, the record shows we have an affidavit by the plaintiff's manager stating he was unaware that the premises, that they were closed in business or that the premises were being abandoned until he got the keys in the mail after
service was
effectuated. And
pull up your mask.
I apologize.
It happens to us. I just have to remind you. Go ahead.
And given the the case law on this, and given the fact that, as stated in the affidavit, the defendant's signage was still on the place, we submit that service was appropriate, was affected appropriately.
Okay, you can continue with your other issues. I didn't want to.
I'm sorry.
I just wanted you to hit that issue since that was one of the issues raised.
My only other point is that the defendant, I guess the defendant is claiming or contending that impossibility in the defendant's case is not economic. It goes to non-economic matters. But I would point out that in page 4 of the respondent's, of the appellant's brief, that the appellant states, the landlord made, quote unquote, the landlord made no allowance for the exigencies, but insisted on full payment for rent and additional rent. And as the appellant's brief also refers to the fact that the defendants retained counsel to attempt to negotiate a rent reduction or rent abatement. And again, if this was so impossible to maintain, if they couldn't maintain, if this was so impossible, that's belied by the fact apparently it was possible if they got a certain rent abatement. And that's just the last point I would like to make.
Go ahead.
That's my last point.
Okay, thank you. I misunderstood. All right. I misunderstood what he said, I'm sorry. You may proceed.
Your Honor, so in response to your reference to the letter of the law, I respectfully point out that it's our position that the New York jurisprudence on impossibility or frustration purpose does allow this court.
Except that this court has already ruled on this issue.
Your Honor,
Frustration of purpose with respect to closing of businesses and lease payments during the COVID period. We've ruled and it does not go in your favor. So how do you address that precedent?
Right. So, Your Honor, our view is that based on our review of the precedents and our review of the case laws cited by the landlord, virtually all of those cases deal with economic impact or financial hardship. None of them deal with anything even remotely similar with what my client experienced, a racially and ethnically motivated hate crime that is life-threatening and that is pose a serious physical threat to their personal safety. That's what we think that this court should review this case as a matter of first impression, and we think that the New York jurisprudence on frustration of purpose and the impossibility does permit that kind of a ruling.
Are you saying that, one, was there a police report of the first attack?
There was not a police report. There was my client's sworn affidavits.
Okay, so it kind of begs the question, right? It's terrible to be the victim of an attack, but that attack, that singular attack, doesn't tell me that this was a group gang that had vowed to come back and come to destroy the business, that the police were involved, were investigating, recommended to the family, you shouldn't open because I think your family's in danger. I mean, if we had more like that, perhaps there might be something to talk about. There might be something that we could consider if that had been the case and the landlord had been consulted by the police department, said, look, your tenants are really in danger, they can't open, whatever. We don't have that. We don't have that.
Thankfully.
Thank goodness. Yes.
Your Honor, I know my time has expired, but may I address the second issue I was planning to address?
I'm going to give you 30 seconds. Talk fast.
Yeah. So, Your Honor, the landlord had actual notice that my client was going to vacate and was going to abandon this property well before the commencement of this action. In fact, in the affidavits...
But doesn't our case law say that in order to officially abandon property, you have to turn over the keys to the landlord?
Well,
and until those keys are in the landlord's hands, you have not been declared as legally having abandoned the property.
Your Honor, my client retained an attorney, and the attorney informed the landlord that they are going to abandon the property. And when the landlord served the 14-day notice on my client, they filed in the affidavits of service they filed, they noted that there was nobody answering the door, and that property seemed to be vacant.
Okay, thank you so much. Have a good evening and a happy St. Patrick's Day to all.
Lobby, be advised, court is over, we got two coming out.